May I please your lordship, my lord, in item number 30, my lord, I have filed an additional affidavit, my lord, small, just maybe call to record, my lord.
Item number
30, 30.
Yes,
A small affidavit is filed with some latest development and some documents, my lord.
affidavit.
Affidavit. Like,
May it please your lordship. Lordship, I beg to mention item number 22. I need to file a detailed affidavit. I'm being granted 4 weeks' time. I've taken the consent of the other.
Okay. Ms. M. Hazarika, Senior Counsel, appealing for response number 226, has sought for 4 weeks' time to file a detailed affidavit on behalf of the said respondents. First of, it is submitted that consent has been taken from the land counsel for the petitioner to make the prayer. The prayer is allowed, release the case after 4 weeks on date to fix by the office.
Obliged.
May I please? No, item number 26, madam.
26.
26, madam.
Yes.
I have taken the concern of the government approval also. To be taken after 2 weeks, madam. Today, madam, I am-
Mr. S. Thakur, Learned Counsel for the petitioner, with the consent of the learned for the respondents. Huh? Mr. Dhor, learned State Council, has made a prayer for adjournment of the case for 2 weeks. The prayer is allowed, is the case after 2 weeks on the date to fix.
May I please the lordship, my lord, I beg to mention item number 11, my lord. I am for the health department. The petitioner is also there, my lord.
Yes,
So, in this matter, my lord, the matter is under process. On last occasion, I submitted one report regarding.
let this first 10 items be over.
Yes,
It will
Yes,
take short time.
Yes.
may I please your lordship? Lordship, with the concern of the other side, I beg to mention item number 24, lordship.
24.
Yes, lordship.
Yes,
Lordship, matter may be listed after 2 weeks, lordship.
after
2 weeks, lordship.
2 weeks, 2016 matter. Okay, on the prayer of Mr.
A. Brahma, lordship.
You're for whom?
I'm appearing for ALR, lord.
On the prayer of Mr.
A. Brahma.
Abraham, learned counsel paying for a petition. This is the case of 2 weeks. You have informed the other side.
Yes, lordship.
It is submitted that consent has been taken.
Much
I
obliged.
beg to mention about listing, my lord. This matter is listed on the.
For admission.
For admission.
Okay, give it to the court.
May I please your lordship, with the consent of the other side, I beg to mention item number 23 of the daily list, my lord.
23.
Yes, ma'am.
Yes.
My lord, matter may be adjourned for the day, my lord.
Okay, Mr.
A. Gayan.
Egan. On the prayer of Mr. Egan, learned counsel for the petitioner, the case is possible for the consent. You
Much
have
obliged.
informed the other side.
Yes, my lord.
May I please, lordship? Lordship, I'm here for the listing of a matter, lordship. It's a.
For admission.
Yes, lordship.
Okay, give it to the court master.
Yes, lordship.
Your Honor, I am appearing before for listing of the matter for admission.
Admission.
Yes. my lord.
Give it to the court master.
My lord, I beg to mention for admission, my lord, for listing.
Okay, give it to the court master.
Obliged.
Just a pure lordship. I beg to mention for listing of a matter. It's a pension matter, man.
Hmm.
It was
Okay,
last
give it-
posted on 2.
Give it to the court master.
Okay. Obliged.
May please, Lordship, I beg to mention item 32 of today's list.
Yes.
Lordship, I am appearing on behalf of Mr. Arbor Pujari. Lordship, he is unwell today, Lordship. I've informed the other side.
Okay,
I'm seeking
Mr.
a-
H. Oliha, learned Standing Council Finance Department has submitted that Mr. R. Borbuzai, Learned Standing Council Finance Department, who is handling the brief, is in this post and has thus paid for listing of the case on another date. It is submitted that consent has been taken from the Land Council for the petitioner to make the prayer petitioners. Okay, the prayer is list. The case after 1 week.
After 1 week, Lordship.
Okay, after a week. On a day to week.
Yes, sir. Sir, I beg to mention item number 10, my lord.
Item
Respondent
number
10.
1 to 10.
Respondent number 1 to 3 file affidavit in opposition.
Oh, 1 to
But
10 is for mediation, sir?
I'll
10.
file reply, my lord. Affidavit.
Item number 10 is also mediation. You wait for your turn.
Lordship, item number 10
Item number 10 is motion or what?
for
Mediation.
Mediation.
So you wait for your turn. Yes, Lord.
Item one, item one. Item one.
Yes, Mr. Khan, what is the area salary?
Area salary.
Regular pension.
Yes,
Let us make an effort.
days before the mediation, Lordship, matter maybe
Suspension has been revoked.
suspension.
Has been revoked. Definitely. You place it. Let us have an effort.
Yes.
The petitioner will also have the occasion to interact also. M. Khan. Petitioner.
Let it go, but my lord, I think it will come back, this case.
Let us have sometimes difficult issues get sorted out.
No, there is a issue of raw.
There has been huge success also.
No, my lord. Section 21 of Pension Act will come in. He has retired and DP is still pending. So there are issues.
Okay.
My lord, let it go now.
Land and revenue. Okay.
Revenue, my lord.
And Learning Council for the respondents. Official respondents are in attendance. Also, the subject matter of this petition is release of regular pension as well as area salary for the period of suspension. Also, 3, 4, 5. First date, 8th of September. 8th of September.
Item number 2.
Yes, sir.
May I please, your lordship? My lord, the matter relates to pensionary benefits, my lord. And then order by which, my lord, recovery has been directed, and that is under challenge, my lord. Now, whether, my lord, it can be decided in the mediation, my lord. Then we show, my lord. Prayer is a page 20, my lord.
Maybe if it is successful, then in future also
My lord.
it could be
Let it
sent
go,
for mediation. Let us have a try.
My lord, my lord.
Then we.
Yeah, Bhuiyan.
Otherwise, we will put it out.
For the petitioner. Learning Council for the petitioner. Recovery
Recovery is there, my lord. That part is now,
and
interim order is there, my lord.
Learning Council for the official respondents are in attendance. The subject matter of this petition is an order of recovery. Per party limit for amounts. Per party limit on account of wrong fixation of pay. Okay. 8th of September. 8th of September.
My lord.
Item 3.
Obliged.
My lord, these orders, once we get, we have to communicate also to the department or my lord. For, cause the officer, they have to come.
Yes. Yes, definitely.
Item number 3.
I think they have been apprised already. Yes, Mr. Devchuri.
Lordship, this matter,
Disability pension.
this disability pension, what has happened, Lordship, is while his disability pension, he has made a claim, while that was being considered, he also filed an application for voluntary retirement. Before his disability could be considered, he went on voluntary retirement. He made a mistake. Perhaps,
Okay, let us have it thereafter. We'll
yes,
make it
yes.
apply our mind. Yes, Madam M. Das.
Lordship, M. Borgohain.
M. or Guhai. Okay, Learning Council for the petition and Learning Council for the official respondents are in attendance. Subject matter of the petition is grant of disability pension, stroke and or voluntary retirement.
No, voluntary retirement he has got.
Okay, grant of disability pension. Okay, 8 September. 8 September. 8 September.
In September. Item 4.
Meena Kumari. Yes, madam. What is the subject of dispute.
Retirement
Okay, retirement benefits. Here, petitioner and counsel for the petition, official respondents are in attendance. Retirement benefits including pension, gratuity, etc. Identified as so and so will you 8 September.
Item number 5.
Ola Nath Ghosh. Family pension and other retirement benefits.
Lordship, this item may be passed over for a week. Learned Counsel is out of the city, concerned council.
He will be back on 8 September.
Within 1 week, he will be back.
8 September.
Yes.
Go for mediation.
Obliged.
Item 6.
Publish for a special SOP. Perhaps. Yes, Mr.
I am for respondent number 5, my lord.
What is the subject matter otherwise?
Family pension, my lord.
Family pension. Okay. Petitioner and official respondents. Family pension. 8 September.
8 September.
Before the mediation.
Right.
Item number 7.
Yes. Also relates to family pension.
Family pension.
Yes.
Okay. Mr. Aish Borbuya, petitioner. Official respondents are in attendance. Family pension. Family pension. Same day. Same day.
Item number 8.
Here, Pankiti. Yes.
Family pension.
Family pension. Okay. Here, Pankiti. And the counsel for the official respondents are in attendance. Family pension. 8 September.
Item 9.
DCRG. Release of DCRG.
Lordship, my senior is on.
No, we are putting it on mediation. Your senior's presence is not required. Official respondent, DCRG. Release of DCRG.
Item number 10.
Yes. What is the subject matter?
Not family pension.
Huh?
Pension, area pension claimed by the second wife, Lordship, without
Okay.
succession certificate.
You inform your client
Lordship,
to participate online also.
Lordship.
Family pension. 8 of September. Look at the order
Lordship.
and inform accordingly.
For admission. Item number 11.
Yes, Mr. Bora, what you are proposing? What is the subject matter?
Subject matter, parity of pay.
Parity of pay.
Petitioners here in
AICTE pay
In
scale.
parity of pay, what is the controls of judicial review?
they are the faculty members of homeopathy.
Monitoring or what?
The pay anomaly committee has recommended, but it is not being implemented by the government, and administrative department has agreed to that. They have sent proposal
So
now
what is
it's
the
pending in the.
what is the controls of judicial review in a matter of pay parity?
But,
Mandamus,
that in fact is
statutory,
very limited.
huh?
Mandamus, they are seeking, my lord.
Or monitoring agency.
They are seeking,
What is the power?
basically, we are seeking.
No, I am trying to find out because this petition is pending for
2015.
10 years.
Yes, ma'am.
What is the contours? Why court is not exercising power for last 10 years?
Thank you, my lord.
Well, a court has the expertise.
No, we are
I don't know.
not for that, my lord. Administrative department has agreed to that. Only finance is
But even if
putting some hurdle.
then mandamus is called for.
Sometimes he is praying, my lord, some development is
Acha.
going on. He told me.
What is this SJNHMCH?
Sohid Jadavnath Homeopathic Medical College and Hospital.
Sohid Jadavnath
Homeopathic Medical College and Hospital.
Homeopathic Medical College. So petitioners are
They are
faculties.
faculty members, my lord. And they are claiming pay parity with their counterpart in allopathy and Ayurvedic same under same Ayush directorate. Ayurvedic professors are getting the AICTE pay scales, but homeopathic are not getting.
Heard Mr. K.M. Halway, Learned Counsel for the petitioner, and Mr. D.P. Bora, Learned Standing Counsel, Health and Family Welfare Department for the and any finance
My lord, P. Nayak is appearing, my lord.
and B. Nayak, Learned Standing Counsel, Finance Department for the official respondents. Full stop. Para Mr. Bora, Learned Standing Counsel, Family Welfare Department has submitted that the state government in the medical education and research department is presently examining a report submitted by the director of Ayush regarding the measures to be taken to improve the functioning of the newly amalgamated SJNHMCH, Guwahati. Full stop. He has further submitted that the department is actively pursuing the process of appointing a principal for the SJNHMCH, and it is expected that once the principal assumes the office, the proposed systematic improvements would be implemented in a phased manner. Likely within the next year, 2026.
In fact, the appointment
Likely
of
in the next year, my lord, their case will be considered. That is the.
since 2015, 2016 itself, health
Because there is
department.
a, my
They are
lord,
saying 2026.
No, my lord,
But
by
that-
that time, the financial benefits or other, actually, my lord, there is a.
Okay, likely within the next
That is
year.
not reflected in this letter, my lord. And appointment of
department-
principal, I think, doesn't have any relation with the.
The
pay
department
parity.
is actively engaged in the process of implementing the directions of this court, and the necessary steps are presently underway. Full stop. In support of his submissions, Mr. Bora has placed an office letter number so and so dated 27/8/2025 of the Deputy Secretary to the Government of Assam, Medical Education and Research Department. Full stop. He has further submitted that the matter would be examined comprehensively once the principal is in position and the proposed reforms are operationalized. This is neither here nor there. Neither here nor there.
Since last 15 years, principal is not there, my lord. Inside principal is working. And my lord, this, I think, do not have any relation with this matter because
No, this
principal
has-
appointment and pay parity.
No, this has
And already, my
relation.
lord, 10 numbers of
It has
petitions are
relation
retired.
in the sense, my lord, because there is a note by the Honorable Chief Minister that the academic and clinical, every facility should be upgraded or it should be made better in that college. And thereafter, my lord, the pay parity or the pay upgradation of the petitioners may be considered. So there is that's why a report was sought for from the Director Ayush. So Director Ayush has submitted a report. So that is being considered now. So once the principal is appointed, other.
Now, whether Director Ayush, that is a department or a
Yes,
director,
I was director.
Director of Ayush.
whether he has suggested something regarding.
Yes, my lord.
pay.
That report is also there in the file record, my lord. On last
My lord,
occasion,
not
I.
only I was director.
1 minute, 1 minute. One by one, I cannot hear both sides at the same time.
I submitted the
Report.
on last occasion.
If
my
it
lord.
is something is there, then it may have some relevance. Otherwise, if there is nothing,
No, it is there, my lord.
he is Anshulekha Datta
Yes, my
Pathak.
lord. Yes, my lord.
Okay. Which part?
My lord.
Okay, after amalgamation of three medical colleges, the major shortage has been resolved. You are working in a rank of
Professor, my lord.
professor,
Professor and
total 10 or what?
out of 13, 10 have already retired, my lord. 3, 2 are in profession and 1 is retired.
Now 3.
Now 3, but they have retired recently, my lord. At the time of filing, they were working.
Hmm?
All 13 were working at the time of filing this petition, my lord.
Regarding the functioning and present status regarding OPD and other facilities, that report was sought for by the department. So Director Ayush has submitted this report. So now the department is working on this report, my lord.
What is that may be promoted as per existing government norms? Is there any existing government norms?
Promotion of, my lord.
Hmm. On what ground you are seeking pay parity qualification?
Qualification, my lord, and the already pay commission provided similar pay to homeopathic doctor and allopathic doctors. Our was not decided. We submitted representation before the pay anomaly committee. and
Homeopathic doctor and allopathic doctor
They are,
serving in the state government.
yes, my lord, they are getting same salary.
Now you are seeking pay parity with the faculty members of medical colleges.
Medical college and Ayurvedic. Ayurvedic are also getting. Nursing, pharmacy, all are getting the AICTE pay scale. Only homeopathic are not being given. And my lord, what my learned friend is submitting is changing the stand. In fact, in affidavit, they have stated, Lordship will get it, paragraph 5 of their affidavit, they have stated,
What are the factors for comparison?
my lord, we are having same qualification, we are discharging same duties, my lord.
Not same duties.
Same way, we are teaching the students in homeopathic college, they are being admitted on the basis of NEET mark. In MBBS also, they are getting admission on the basis of NEET marks.
What is the course duration?
Course duration same, my lord, 5.5 years.
5.5
5.5
years.
years, 4.5 years degree course and 1 year.
Do you have post-graduation,
Post-graduation,
super specialty?
well, super specialty, that part is, government is to develop the.
Do you have
infrastructure.
a hospital also?
Yes, my lord, hospital. Ayurvedic also not having super specialty. Usually nursing do not have, pharmacy do not have. Pharmacy and nursing, they have lesser period of.
Because Supreme Court has identified 20-30 factors for comparison, and it is a case solely of the executive.
Mal.
All right. Court is not an expert in these subjects. Yes, we can only overlook. Yes, Mr. Any
They have-
relevance in this report?
Yes, my lord.
What relevance?
Relevance is that, my lord, the department has sought for a report. On the basis of this report, the department will act, my
I
lord.
have seen just cursorily,
Yes, my lord.
does not appear to have any relevance with regarding the issue of pay parity.
My lord, there is
There is a table.
no. Apart from that, there is a letter from the Honorable CM that a report may be called for regarding the functioning, regarding the service of OPD and academic side, everything, my lord. On the basis of that report, my lord, they may consider.
Which part, where? There is a minute of 2019, 17/6/2019, right? Issued under the hand of Commissioner Secretary to the Government of Assam Finance Department. There it is mentioned that after threadbare discussion with all the officials, it came to the light that Health and Family Welfare Department should furnish a proposal in details in a tabular form with proper justification for granting AICTE pay scale to the faculties of homeopathic medical colleges. Health and Family Welfare Department is requested to prepare a fresh proposal and submit to the Finance Department. That was along with relevant documents, information with proper justification at an early date. There is a meeting. That was in 2019. Any submission of proposal?
Proposal was submitted, my lord. Finance department made some query. We have got it through RTI, and wherein health department has categorically admitted that we are entitled to have. In their affidavit also, their specific environment is there, that we are entitled to that, and they have made the proposal to finance, but finance is not approving it. That is the main hurdle, my lord. And regarding reply to the finance affidavit, we have submitted those office notes where justification is provided by the health department. Finance sought for justification, and that justification is provided by health department.
Mr. Halwe, please also give us some material regarding the scope. Scope.
Next date I will.
Find out,
Apprise.
making research to scope to intervene in such subject, which is clearly a case of pay parity, seeking pay parity.
In 2007,
Okay.
2021,
Sure you.
Supreme Court my lord. May not be unreasonable.
Likhok. Mr. Bora, in view of the such above submissions made by Mr. Bora, Mr. Bora shall furnish a status report as regards the progress made with regard to the report submitted by the director of Ayush. So stop, please the case after 1 month. Later, please the case on. This is what?
My lord, in terms of this letter, my lord, the report was sought for, my lord.
Where it is situated? Homeopathic College?
It is Panjabadi. Earlier 3 colleges were there, now amalgamated into one in Panjabadi.
Nagaon and Jorhat has been amalgamated to this one, my lord.
Okay, status report, huh? On next date, should joke.
1510.
Obliged, my lord.
Much of it.
Items 12 and 13.
Here, please, your lordship. Lordship, these cases were heard by Honorable Justice Mr. M.R. Pathak. And the judgment was reserved, my lord. The final arguments were also submitted, my lord. But the Honorable Judge was.
That is not going to serve any purpose now.
No, my lord. Yes. Today, I would like to proceed, my lord. My learned friend is also ready for the hearing, my lord. Lordship, flag I is the amended writ petition.
Huh?
Flag I in the file is the amended writ petition, my lord. Flag I.
Aye. What I amended the petition you
Yes,
say?
my lord. Filed on 7/12/19.
What I? Unnecessary document board details. গাঁঠিটো খুলিব পাৰিলে গাঁঠিটো খোলাই যাম আৰু আগৰ খিনিৰো গাঁঠিটো খুলিব উঠাব লাগিব বিচাৰ কম পিছত আই কোনটো
ভেৰিফিকেশ্যন এক্সাৰচাইজ দিছে তোমাৰ ছেকেণ্ড কেছটো এইটো ভেৰিফিকেশ্যন তোমাৰ এপ্লিকেবল হ'ব ফাৰ্ষ্ট কেছত নহয় মানে দেও মানে তোমাৰ এইটো ইলিগেল হয় দোজ হু কাম মানে ফ্ৰম দ্য বেক ডোৰ এক্সাৰচাইজ কৰিব লাগিব অলৰেডি ভিজুৱেশ্যন কৰে সিহঁতক ৰাইট টু হিয়াৰিং দি পেলাই এটা হেৰি কৰা হৈছে ভিজুৱেশ্যন কৰা মতে ল'ব দিয়া
amended in what form?
My lord,
Amended in cost title or something else?
amended my lord, during pendency of this case, a vigilance inquiry report was obtained, my lord. Then we filed a petition for amendment of the writ petition, my lord. That was allowed. Lordship,
Assist me out.
If Lord allowed, may I just place this case, my lord? My lord, is similar to.
You will place the case. If I don't have the documents properly, I will struggle.
Lordship, I have got it, my lord. Flag, my lord, flag Y actually. Previously it was I, then changed, my lord. Mandatory petition.
All of into the option. Two. এখন খোলো 1 minute
My lord.
এখন খুলি এইটো চাওক এইখন আননেচেসারি এইখন আননেচেসারি আগৰ ৰিপিটিশন বাকিখিনি ক্লিয়াৰ হা হৈছে
Yes, my lord. My lord.
unnecessary documents are many.
Many, my lord.
Let me get out of
My lord, there is a additional affidavit that will also be relevant.
let us have your writ petition amended writ petition.
My lord.
Cut off. কৰিলে এইবোৰহে ৰাইট শান্তি কৰিম এখন গুচাই দিলে এইখন পিছত ঠিক কৰি দিব হা অ'কে পিছত ঠিক কৰিব পাৰিব ন অনাগতীয়াল ৰাখিলাম এইবোৰ আপোনাক ৰাখিব নাই এইবোৰ ঠিক কৰি দিব হা So you have the amended writ petition
Yes, my lord.
and additional affidavit,
Additional
right?
affidavit.
One by one.
Yes, my lord.
And then
Additional affidavit dated.
One affidavit in opposition by respondent number 25.
Yes, my lord.
Then an addition, affidavit in opposition by respondent number 229.
Yes, ma'am.
Then an affidavit in reply.
Reply, my lord. Yes.
These are the documents?
That's all, my lord. Yes,
So now we have a slimmer version.
my lord.
Yes.
My lord, the petitioner was a candidate for the post of Sahayak under Romia Electrical Circle of APDCL, my lord. The selection was conducted in the month of July 2013, my lord.
What is the process by which it was initiated?
My lord, an advertisement was
Where is
published
that?
at page number 32, my lord.
32.
Yes, my lord. At page
It was in which year?
in 2013, my lord. 9/4 date of advertisement is 9 April 2013.
9th April.
Yes, my lord.
Where from we can get it?
2017, my lord. Because
9/4.
yes,
9/4.
2013 date of advertisement.
Both of you agree?
Yes, my lord.
Yes. Let us see advertisement.
Yes, my lord.
32.
At
Page 32.
Yes, my lord. Somewhere in the middle, lordship will kindly find eligibility of candidates. The heading.
What is the post?
The post was applications are invited for the post of Sahayaks, my lord.
And you are aspiring for what? Which this circle?
For Romia Electrical Circle, my lord.
1 minute.
Where
Rongia.
Romia Electrical Circle.
And what is in the bracket?
Within bracket is the number of seats available in the circle, my lord. Number of posts.
Post.
Yes, my lord.
This is a
20.
stipendary post.
Yes, my lord.
Huh?
Yes.
As a trainee. Initially, it will be a trainee.
Yes, for 1 year. Then
what?
Then they will be regular as subject to report of the officer. When
They will be appointed as Sahag in the band of friends with great pay, other allowances. And this is under the rules of the company. So, Rongia Electrical Circle, 28 number of post.
reserve, my lord.
Okay,
Yes.
now eligibility.
Yes, my lord. As per the advertisement, there were two eligibility categories, category A and category B. Category A was reserved for candidates having ITI certificate. And category B is reserved for those temporary workers engaged in any power utility having an experience of more than 3 years working as Sahayak. My lord, category B is relevant here.
Workers engaged in any power utility to work as Sahayak, power utility. Then, party performing the job Congress for more than so and so. The applicant should not be so and so. It should say corporate engaged in power, blah, blah, blah.
Here, my lord, not a single candidate from the category A was selected.
Oh, that certificate from general manager.
Yes, my lord.
Oh, that thing.
Here, my lord, a
Oh,
vigilance
this one. So you are that category.
Yes.
Category B.
I was from category A, my lord.
You are from category A.
Yes, but not a single candidate from the category A was selected, my lord. And all candidates were selected were from category B, who were given.
So you are having ITI pass, ITI certificate.
ITI certificate, my lord. Yes.
In the trade of wireman electrician.
Yes, my lord.
Where it is?
My lord, I have not enclosed, but I have enclosed the admit card, my lord, at page number 35.
Where you are saying that you are in from that category one.
My lord, admit cards were issued because I fulfilled that criteria. And
Is it mentioned category A?
my lord, no particular seats were reserved for a particular category.
Have you mentioned you are from category A?
Yes, my lord, yes. I have mentioned in the writ petition. Page 5.
Perhaps not mentioned.
My lord, in my reply, I think I have mentioned in my reply to the affidavit filed by.
You have not annexed your certificate.
Certificate is not annexed, my lord. That is,
Not annexed.
But admit.
No, where is your reply? Which statement?
Yes, my lord. I will. My lord, affidavit in reply on behalf of the petitioner.
Okay, I have seen paragraph 5. Okay.
Paragraph 5, my lord.
Mhm. Then the admit card was issued.
Yes, my lord.
Let us see admit card
Admit card is at page number 35.
35.
Yes, my lord.
There will be a physical fitness test.
Yes.
You appeared.
Appeared, my lord.
Appeared.
He appeared.
Then interview you appeared.
Also, yeah, I appeared in the interview, my lord.
Okay, good. Then what happened?
My lord, my lord, then my lord, lordship will kindly come to page number 36, my lord, which is the appointment order, my lord. Page number 36.
Okay.
On 4th March 2014, this appointment order was issued.
4th March.
Yes, my lord. Name of all.
Acceptance by the students who are appointed as trainee or higher for the interest of companies work.
Names of all private respondents can be found in this list, my lord.
Private respondents are represented.
Respondent number 22.
Huh? Others?
So notice was served upon other respondents, and as per order dated 27 January 2020, steps on all private respondents were completed, my lord.
1 minute. Which order?
27 January 2020.
27 January. 27 January order will be also. 27 January 2000?
2020, my lord. 27 January 2020.
Okay. Okay. Yes.
My lord.
Let us see the selection list again.
Yes, my lord. In this appointment order, serial number 1 is respondent number 17, my lord.
Okay.
And
you have not made all of them respondents.
I have met all of them respondent, my lord.
How many, here it is 28,
Those, I have made,
not all of them.
not all of them, my
It
lord.
looks like,
Those whose appointments were found anomalous, only those were
okay, 10 to 20,
10 to 25.
25, meaning thereby, how many?
Uh,
16,
15, I think, my lord.
10 to 25. 16.
16, my lord.
Okay, you have, out of this list,
Yes,
out of this list,
out of this, my lord.
you have made
Uh,
16 of them respondents.
Yes, my lord.
Okay. Yes.
Yeah, my lord, when I got an information that there were anomalies in the selection and appointment, I filed an RTI application, and that RTI application was ultimately heard by the Chief Information Commissioner, my lord. And the Chief Information Commissioner passed an order. That order is at page number 40, my lord. Please come to page number 40. In this order dated 16 July 2016, the Chief Information Commissioner directed the concerned APDCL authorities to furnish certain documents, my lord. And relevant paragraph is somewhere in the middle, starting from the word, from perusal of RTI petition dated 12/12/2014, my lord.
Yes.
Basically, the Chief Information Commissioner directed to furnish the APDCL authorities the waste payment records at least for a period of 3 years before the appointments of certain candidates, my lord. And these candidates were respondent number 10 to 16, my lord. And also their initial date, their initial engagement, date of engagement on daily waste was directed to be provided to the RTI applicant, my lord. This RTI applicant was a friend of the petitioner, my lord.
There perhaps lies the crux.
Yes, my lord.
Wherefrom they can give waste payment.
Yes, my lord. After this,
If it is any power utility,
any power,
it is not defined.
not defined, my lord. Yes.
Not defined.
Yes, my lord.
Correct?
Yes.
And
Correct, my lord.
APDCL, they are not under APDCL. They were not under APDCL
My lord.
prior to their application or engagement as Sahaya.
But certificates were issued by APDCL authorities, my lord.
Certificates are issued by an official of the APDCL in the rank of Assistant General Manager,
My lord, yes.
right?
Yes.
So this part of the document
Yes.
that you sought under RTI,
Yes.
waste payment.
Yes. My lord,
Is it realistic? I'm asking you just think.
my lord, yes.
Waste payment
Waste payment
for
records.
at least a period of 3 years before appointment as Sahaya.
Dates were sought, my lord.
Sought.
Sought.
Whether they have the custodian position.
But my lord, as part of relevant,
Okay, then what you got?
my lord, I have got a series of documents starting from page number 89. And
So what is relevant?
yes, my lord. Page number 81 is most relevant, my lord. 89 was
81.
89, my lord. Sorry, my lord. 89,
89.
my lord. This is a, my lord, report submitted by Chief Executive Officer in response to the Information Commissioner's order, my lord. Here in this tabular format, serial number 1 is Sattar Ali. Kindly see the remark, my lord, in the table. Sattar Ali, who is the respondent number 10, worked honorary in Baihata Sariali Electrical Subdivision, BCESD. No payment and attendance record, my lord. So
What is BCESD?
Baihata Sariali Electrical Subdivision, my lord, in short form.
There the whole thing happened
Yes, my lord.
in this recruitment process.
Yes.
I think there are many litigations earlier. The whole thing happened there.
They say they have Here it is written that work or he
They are-
worked honorary in BCESD.
They, everybody
he's-
played within that area.
My lord, yes.
We cannot go into this.
My lord, next next please come to page number 90, my lord. This is his experience certificate of respondent number 10. Here he is declared a daily wage the daily wage labor.
Which one? Serial number?
Page number 90, my lord. This is-
90.
Yes, this is the experience certificate of the respondent number 10, my lord. Sattar Ali. And here in this certificate, he was declared a daily wage labor under Bahata Sarali Electrical Subdivision from time to time. But as per the relevant office memorandum, there must be his name must be in the payroll, my lord. And also he should have worked continuously for more than 3 years, my lord, not from time to time. Similar pattern is seen in other in case of other respondents also, my lord. May I lead your lordship to the relevant provision of that is the office memorandum, my lord.
It is mentioned August 2009 till date.
Yes,
So period of 3 years
my lord.
has been covered.
My lord, no, not covered. My lord, the first thing is that he has no payment and attendance record, my lord. His name was not in payroll of the APDCL, my lord. And that is a requirement under the office memorandum, my lord, relevant office memorandum. And further, a person who was appointed from time to time cannot be appointed, my lord. Cannot be given a certificate, my lord. He has to work continuously for more than 3 years. my
Where
lord.
is the office memorandum?
Yes, my lord. Office memorandum is with the additional affidavit filed on 6 November 2017, my lord. Previously, it was flag B.
B.
Yes, my lord. Previously, it was flag B and additional affidavit filed on 6/11/2017. Here, my lord, the relevant page is page number 6, from which the office memorandum starts. Here, kindly come to page number 6, my lord.
Yes.
Somewhere in the middle, lordship will kindly find eligibility of candidates. 2 categories of candidates are eligible to apply. Category A for candidates having ITI certificate. Then, my lord, next relevant is category B. Temporary workers engaged in any power utility to work as Sahayak. The temporary workers engaged in any power utility for performing the job of Sahayak continuously for more than 3 years. My lord, here the word
1 minute.
category B, my lord.
1 minute. Yes.
Yes, my lord. Category B. Here, it is written that the temporary workers engaged in any power utility for performing the job of Sahayak continuously for more than 3 years. Here, the word continuously is placed, my lord, in this memorandum. So, my lord, a person who was appointed from time to time is shall not be issued as the experience certificate, my lord. And there is also another rule, my lord, which prevents arbitrary issuance of experience certificate to the candidates who does not have name in their payroll.
Now, Mr. Vikas,
Yes, my lord.
by this office memorandum,
Yes.
you said the advertisement was on 3rd April
My lord,
2013.
9th April.
9th April.
9th April 2013.
Huh. And this is a decision to introduce trainee scheme.
Yes, yes.
A
Entire
newly selected person in the
entire selection should have
cadre
been-
of Sahayak.
Yes, my lord.
This is a futuristic thing.
My lord, after publishing of this office memorandum, they have
There is a difference. See the first line.
Yes,
APDCL decided to introduce trainee scheme and
Yes.
newly selected person
yes.
in the cadre of Sahayak will be engaged on trainee for one period so and so. Then next para to adopt a uniform policy by different selection committees under the APDCL towards selection of candidates. Whether this is made applicable,
My lord, advertisement seems to be influenced by this office memorandum, my lord.
influence is the different thing.
But
Because this is otherwise for future.
my lord, when we submitted RTI application for seeking the prescribed guidelines, this was provided, and my learned friend will not oppose this, my lord. That the entire selection process is governed by this office memorandum, my lord. I believe that after making these prescribed guidelines, they have published the advertisement and one wanted to fill up the post, my lord, as per these guidelines.
Yes, Mr. Soma, it is guided, this
Yes, my lord.
selection process is guided by this office memorandum.
Yes, my lord, it is, my lord. In fact, similar cases of different circles were there. So this has been a uniform stand, my lord. And in fact, my lord,
Okay.
My lord, then please come to page.
So this is your standard, this is followed.
yes, my lord.
Okay.
Then lordship kindly come to page number 7, my lord. Procedure for application. Procedure for somewhere in the middle, my lord. My lord, here I would like to read this relevant portion. Procedure for application at page number 7.
Page number 7, internal page.
Yes, in next page, my lord. Next page of this additional affidavit.
Yes.
Somewhere in the middle, procedure for application. I would like to read, my lord. Application from temporary workers in any power utility should be submitted to the Deputy General Manager of the respective circles, forwarded by the subdivisional engineer of the subdivision concerned. The certificate should be issued within previous 30 days from the date of submission of application. The certificate would clearly mention the period with dates from which the person has been working. Assistant General Manager concerned will cross-check with payroll before countersigning. The application must be accompanied by an experience certificate. My lord, here the word payroll is there, my lord, and this I believe this is this provision is included in this memorandum, my lord, to prevent arbitrary issuance of experience certificates, my lord. Before issuing any experience certificate, the concerned Assistant General Manager.
Read the first line because
Assistant General Manager.
application from temporary workers. Now next 4 words, see the expression. In any power utility.
Yes.
And they have used all these other entities as any power utility perhaps.
Yes, that is
This kind of litigation is going on since 2013.
my lord. Yes.
What is their interpretation of in any power utility?
My lord, they are certified to be engaged
It is a third party.
in Bahata side.
This power utility is a third party, any power utility.
But my lord,
It is not APDCL
yes,
or its associated
no, yes,
directly.
yes.
Some contractor, some electrical contractor, all these are termed as,
Other power.
is it correct?
Yes, madam.
But
They have been identified as Any power utility.
But they have, in the certificate, they have stated that,
He will check, he will not retain.
yes,
The problem lies there.
yes. But my lord, in this case, there is another factor, my lord. A
We have
vigilance,
seen already 500 this kind of certificate.
yes, my lord, but in case of all those cases, no vigilance
Okay.
inquiry was conducted, my lord.
No, sir. Now I remember now.
My lord, this case is,
One.
okay, man.
Now I remember I did many cases.
Yes, my lord. That is what I was, I had
Now
all
I
the judgments.
remember I did many cases on these certificates. I should not.
Yes.
Lordship is very right, but.
Right. I did many cases on these certificates and all this.
But
How
you know, in all those cases, there was no vigilance inquiry report, but in this case, a vigilance inquiry report.
No, sir. I said in a different context. What I said is that
My lord had appeared. That's what I was about to say in the start.
as a council.
Yeah.
So many submissions are made from my side on these certificates. So I should not, I think I feel myself. Let it be.
Lordship, kindly
Not by
please
me,
sort
not
this,
by
my
me.
lord, so that matter
Will
may be
not
finished.
fix, will not fix. Release the cases. Two cases, release the cases before any other events without me. Yes, sir, I have done dozens of cases. Now I remember. On this, many judgments were also rendered at him.
Yes, ma'am.
Correct? Am I
Yes, my
correct?
lord. And that had gone to the appeal and now, in fact, that same judgment would apply in his case also.
Okay. Right, Mr. Vikas.
My lord, kindly please give a short date in.
No, I will not give the date.
Oh, much lord. Okay, my lord.
You correct কৰিব লাগিব, গাঁঠি থব লাগিব।
Item number 14.
আগৰ নিচিনা কৰি থৈ দিব, আগৰ নিচিনা কৰি থৈ দিব। মই খুলিলো, কিন্তু বেলেগ কোৰ্টৰ কাৰণে দিগদাৰ হ'ব ন? Yes,
Matter pertains to wrong fixation of pay, my lord.
sure.
But on the last occasion, Lordship, court has the maintainability of this petition before here, Lordship.
Okay, we'll first find out the facts, then maintainability. What is the
Lordship,
maintainability?
jurisdiction of Honorable Cat is there, Lordship.
How? Is there any notification?
Lordship, it's a water resource department. It will be come before the, or the first instance, it will be the CAT.
Huh?
Section 14.
Let us see section 14, Administrative Tribunal Act 1985. There must be some notification.
Yes, Lordship.
Is there any notification?
Lordship, it was in the schedule, Lordship, Water Resource Department,
Let
Lordship.
us Administrative Tribunal Act.
My lord, this
এটা কিতাপ আছে, কিতাপ আছে।
is দেখুন দিয়ক,
কিতাপ
mark
আছে,
কৰা
আপোনাৰ
আছে।
কিতাপ আছে।
My lord, I have marked these, lordship.
Administrative Tribunal Act 1985.
The flag marks. my lord.
Page number 14 is the jurisdiction, section 14. And the schedule is Lordship 103.
Yes, that's I know. Schedule.
Lordship 103, serial number 39. It is in page number 104.
Schedule.
What 39, Ministry of Water Resources.
Department wise
Yes,
classification.
Lordship
Serial number.
39, Ministry of Water Resources.
Yes, what do you say then?
My lord, on this point, my lord, I'd like to make submission regarding, my lord, despite having the alternative remedy, my lord, if the petitioner able to establish his case under the three conditions, my lord, so far is the violation of fundamental rights is concerned, second is the natural justice violation,
No, this is regarding this.
yeah. my lord.
Section 14, let us have a
Page
look.
14, page 14.
It's given.
14.
Yes. Sixteen.
Whether this Central Water Commission is under Ministry of Water Resources?
Yes, Your Lordship. Cost title, Lordship. Union of India, page 3. Representative Secretary, Government of India, Ministry of Water Resources.
Okay, now, in view of say, section 14, more
Look.
particularly if it is within a schedule,
Lordship.
right? Then whether the jurisdiction under 226 is considered to be ousted.
Not outstated, but at the first instant, it should be before.
No, because did you raise this issue earlier?
Yes, Lordship.
Huh?
Lordship, court has issued, court has.
Court has, on the last date, I have seen,
Prior to
but
that, prior to
this
that,
is pending since 2019.
19.
Yes.
Prior to that, Lordship, it was, court has
My lord,
maintainability of-
110/2024 order.
110, 2000.
2024.
Honorable Court has the
Where is the notification?
that notification, Lordship, it will schedule, that schedule will come, Lordship. The ones which are the departments.
Appendix 6, the first one. Appendix
That
6.
day you submitted that
Yes.
there is a notification already.
Lordship, that appendix, Lordship.
Huh?
Lordship. That appendix 6 is the note, it was in the book, already in the book. Honorable Court want, if there is any specific notification or
Where is that notification?
that my, from my department, it said it is in the book appendix, Lordship, appendix 6, that Ministry of Water Resource will fall in the jurisdiction, Lordship.
Because I remember something, whether in such a case, 226 jurisdiction should be exercised or not.
L. Chandran's case, Lordship, paragraph, last paragraph.
No, that,
written
that,
First instance will be the.
no, that is L. Chandra,
Lordship.
1997 perhaps.
97.
That is regarding
Ju-
judicial review of an order of
But
administrative tribunal.
tribunal, Lordship.
This is not directly on the point that 226 jurisdiction is to be exercised originally.
Lordship.
As a power of judicial review can be exercised
Sized.
in respect of an order passed by administrative tribunal. But that is not the case here.
No,
He has approached directly,
directly, Lordship.
because I remember one instance. Somewhere there is the judgment on it. Oh, iPad one. Yes.
Yes, my lord.
And what is the preliminary issue?
Yes. Yeah, my lord, the wrong fixation of my basic pay.
No. That is not a preliminary issue.
Maintain-
That is on merit,
Merit,
Merit.
maintainability.
maintainability.
Yes, my lord. So in support of my mental health question, my lord, I filed this case in the year 2019. I retired from service 2017, my lord. And prior to my retirement, my lord,
That was in existence.
yes, my lord.
Ah,
Then I
that is on that point.
that I approached the 2019, my lord, And 2024, the affidavit filed by the objection raised by the, but in the affidavit, not even single point raised regarding maintainability question, my lord.
That can
Then-
be raised
Yes.
at any time.
And that.
Question of law.
Then, my lord, I prepared for reply, when on last occasion, this occasion, my learned friend has raised regarding the alternative, despite alternative remedies available. So this honorable court is no jurisdiction to.
No, this is not an, no.
Yes.
No, the point is different. Alternative remedy is another thing.
Yes, my lord.
Suppose from a tribunal,
My lord.
let's say, for example, tax
Yes.
commissioner of appeals
Yes, my lord.
has passed an order.
Yes, my lord.
There is a provision for appeal.
My lord.
Or instead of going there, if he comes to the court under Article 226,
My lord.
then yes, it is an alternative remedy. So court may not exercise. But at the same time, it can exercise in an appropriate case on four,
Yes, my lord.
right?
Yes,
Four situations.
yes,
Violation of natural justice,
Please,
fundamental right, virus and all.
yes.
Right.
Yes.
But here is a question, there is a original jurisdiction.
Lordship.
And it is not an alternative jurisdiction. The question is that. Have you understood? It is not a case of alternative jurisdiction.
Original jurisdiction.
Sometimes court is exercising this business contractual will, which should have been before the civil court.
Civil court.
Or any arbitration.
Right. But
And,
here is
I
a case,
understand, my lord.
here is a case, original jurisdiction, question lies there. Because once I exercised, Mr. Reka, once I exercised, then thereafter many litigation ensued.
My
It
lord.
gave birth to 5 litigations.
My lord, the case laws, my lord, I have prepared for this maintainability question, my lord. Though your
Let me
lordship
see.
has correctly pointed out regarding the issue involved regarding original, my lord. So, yes, so in this regard, lordship, I pray for you another 1 week's time so that I could.
Let me
Yes.
have a look now.
Check. Original.
Is there any mention in the L. Sundar Kumar case?
Lordship, L. Chandra Kumar case, last paragraph 80 only says, Lordship, that at the first instant, it could be kept. Paragraph L. Chandran, Lordship, last paragraph, Lordship. Para will be 7 in my Supreme today is 79. In view of the reasoning adopted by L. Chandran. In 1970. 1997, SC 516. 1997, 3 SSC 26. Excellent. 1997, 3 SCC, 3 SCC, 261. 261. Better. More yet, 7 last paragraph. 79. 79. Action. Three SCC, 261.
1992 to 4 SSC 432. In 1995, 4 or 5 SSC. 6, 7, 8. Ah. 2002, 4 SSC. 145. এইটো লাগিব আৰু প্ৰথমটো L. Chandra Kumar also. That has been interpreted. এইটো এক মিনিট
24 4 SSC.
2002 4 SSC 145. That L. Chandra Kumar Constitution Bench judgment has been interpreted that though the High Court under Article 226 of the Constitution has wide power, but in view of the restraint imposed by the judgment of the Constitution Bench of the Honorable Supreme Court in L. Chandra Kumar, the High Court ought not to have entertained the writ petition. Exclusive jurisdiction of the CAT and 3 other judgments.
Lordship,
You examine those, we put it
yes.
on Monday or Tuesday.
Yes,
We'll take up
Tuesday, Tuesday.
You come up at 10:30?
Yes,
We'll
my
take up at 10:30.
Yes,
Yes, Mr. Roy.
Lordship. Tuesday.
This
দুই তারিখ না?
And what is the paragraph? Okay, it has been discussed
L.
in the last,
Kumar is the last paragraph.
2002 4 SSC, it has been discussed.
145.
That because of the Constitution Bench judgment, it should not have entertained.
Lordship.
And nobody argued before me once,
Yes.
and I entertained and disposed of the petition, and it gave birth to 5 more litigations. So I am cautious
Yes, my
now.
lord. Yes, yes, this time, my lord.
Heard Mr. P.K. Dekal, learned counsel for the petitioner, and Mr. S.S. Roy, learned central government counsel for the respondents. Post of Mr. Roy, learned central government counsel has submitted that in view of section 14 of the Administrative Tribunal Act 1985, more particularly, subsection 2 thereof, the Central Administrative Tribunal has exclusive jurisdiction to decide on the subject matter, to decide the lease involved in this writ petition. And therefore, the instant writ petition is not entered in view of the constitutional judgment in L. Chandra Kumar versus so-and-so, 1997 3SC something. Mr. Teka, Kasapura petition has sought a short accommodation to address on the point, raise the case on Tuesday.
2nd September, 29.
Nip to place.
Every your lordship.
Yes.
Every your lordship. Lordship, the petitioner is the wife of an employee, lordship. He was an work charge employee, lordship, but he was appointed against the sanction post, lordship.
I'm just getting a judgment, madam. I'm just getting a judgment.
No, lordship, if lordship may have a look at page 21, lordship, it's his appointment order, lordship. If I may read, lordship. In the interest of public service as approved by BSE via letter number Iman and dated 9/4/98 and subject to the approval by government, Sri Bidang Basumatari, son of late Kontala Basumatari of village Iman, is hereby appointed as WCSA in post of Sri Amadur Rahman. WCSA who has already transferred from this division under the establishment of the undersigned in the scale of pay of rupees Iman to Iman. Lordship, it means that he is a work charge employee who has been appointed in a sanctioned vacant post, lordship. Now, lordship, he passed away in 2018, lordship.
He is the appointing authority.
Lordship.
Is he the appointing authority? This authority
Yes, lordship.
is an appointing authority. For a post, suppose
Lordship.
sectional assistant, perhaps. Amdadur Rahman,
Lordship, he was the employee who has been transferred,
Right.
transferred, lordship.
is he an employee, appointing authority?
Lordship,
Because this is with a caveat as approved by so-and-so, subject to approval by the government.
lordship.
This appointment is subject to a caveat.
Lordship, but
Subject to approval by the government.
yes, lordship, but this approval,
Is he an appointing authority?
lordship, executive engineer Peter.
Cannot, madam.
Uh,
Appointment. With the concurrence of the finance, madam, the government. It has been even an under secretary, madam. We could have, madam, but executive engineer is then, madam, engineer, madam. He is just there to execute works, not to appoint, madam. He may take in somebody on temporary leave as master worker, work charge, this is the thing, madam, but he cannot regularize. Regularization has to be done from the government, madam, with the concurrence of the finance.
Lordship, that is.
Otherwise, who is the appointing authority for a sectional assistant?
Government, madam.
Huh?
Government.
This is which department?
This
You have
is
a
lordship,
set of rules,
PWD.
Mr. Nayak? You have a set of rules also for this?
Regulation, lordship.
No, not regulation, the rules appointment.
No, so far as this case is concerned, he was initially appointed as workers in the year 1998 and expired in 2018. Now the wife is before your lordship claiming for family pension. Now, this is an issue, lordship, that has already been decided, lordship.
Nagaland case.
So many cases, lordship.
Nagaland.
Nagaland is their state of Nagaland versus
Nisevi
Nisevi.
Asumi.
That is 1 day regulation. Main case is Uttar Haryana Bijli Vitaran Nigam, lordship. Same set of rules, just like ours, lordship. Another case is there, Ujjala Narjari by our division bench, lordship. Another case is Sunita Burman. This is 2023 case of Supreme Court, lordship. Same issue. Regularization, without regularization, works as employee. Not entitled.
And plus posthumous.
No.
Nisevi Asumi is posthumous.
So far as Nisevi Asumi is concerned, 2 judgments are there. One by the Supreme Court, one by the coordinate bench of our High Court, lordship. If during lifetime his service could not be regularized, after retirement, no question.
Have you seen Nisevi Asumi?
Lordship.
That is 1 day regulation.
There is a lordship, Supreme Court judgment, lordship. It's a recent judgment, lordship. Jaggo versus Union of India and others.
Jaggo is a judgment persons to it. This is
Lordship, the Tempuna.
Safaiwala Lordship.
No, that is the different case. Lordship, now hearing the case is that after ending 20 years of service,
What is the stand?
Lordship.
This is a short facts.
Yes, Lordship. Lordship, the question, I mean, the pertinent question here is that he was working as a work charge employee, Lordship, in a sanctioned vacant post. And he was receiving the regular pay, Lordship. ROP, he was receiving the enhanced benefits he was receiving as like a regular employee, Lordship. And he had made many requests to the authority for regularization of his work, Lordship. But that had not been done, Lordship. Now, Lordship, he expired in 2018. He died in harness, Lordship.
He service rule concern. On service with just a
Lordship, our stand is that if
PWD.
service may be posthumously regularized for 1 day, Lordship. After that, pension
That
benefit.
is what had happened in Nichebi Asumi.
Yes. So
1 day regularization.
Like that.
that is one aspect, Lordship.
That is one.
That is one aspect, Lordship.
But
Look
in
into it. Look into it.
2012,
Your case also will look into it.
Lordship, in 2012, Lordship, government issued one notification. Two decisions were there, not to regularize any further. And the second was not to create any supernumerary post for 1 day, Lordship. Initially, that was challenged, Lordship, set aside by a learned single bench, Lordship. Subsequently, state preferred an appeal. Appeal, Lordship, this is the same appeal, Lordship, Upendra's judgment, Lordship. There, the learned single judge's order was reversed.
Okay, we'll go to the decision. Let us see the facts. That is in 1998. Where is the set of rules, Mr. Nayak, for PWD for subordinate cadres?
No, this is works as appointment, Lordship.
No, just for, I'm finding.
For initially, department follows, Lordship, that is district or TSL, ministerial service rule, Lordship.
But you have PWD's rules are there, I think.
So far as work service is concerned, Lordship.
No, section is.
Section is the rule is there.
Yes,
No,
yes.
we do not have our own rule, Lordship. We follow the rule of the irrigation department.
You follow the
Yes,
rule of
irrigation, Lordship already done
something.
one similar matter, Lordship, that junior engineer matter, Lordship. It's a case relating to APSC appointment. They were claiming that it should be conducted by the commission, not by the APSC.
There that section.
There, your
assistant-
Lordship went through that rule of irrigation department. That is it.
Section assistant post is there.
Yes. Section is.
And there, who is the appointing authority?
Is a chief engineer, Lord.
Chief
Chief
engineer.
engineer. Then, Lordship,
that irrigation-
section is then to junior engineer,
Yes.
then APSC, Lordship.
Otherwise, it is a chief engineer.
For
He
section.
is the appointing authority.
Yes, chief engineer. Rule, we do not have any of our own rule, Lordship. We
You follow the irrigation
irrigation.
department subordinate service.
Subordinate service.
Also, Lordship, in Upendra's case, Lordship, it is for temporary work charge employees not in a sanctioned vacant post.
Don't
Wait,
pay
wait,
that.
I am
Don't pay
not
that, please.
in touch with service jurisprudence for many years. It takes some time for me. Okay, when did you, when her husband expired?
Lordship, 2018, Lordship. He expired on 26/2/2018, Lordship.
And what is your supporting document?
Lordship.
So
for-
you got revised pay.
Yes, Lordship. It's on page, grade pay regarding, Lordship, from page 33 it starts. Regarding pay. 33, and Lordship, increase in pay, page 37, Lordship. Last line,
Whether this is surviving page 43, this office memorandum,
Lordship.
it is still surviving.
This, page 43, yes, Lordship. The regarding the,
Yes.
It survives.
it's surviving, Lordship.
Lordship, here the deduction of 3 years, Lordship.
Consequent upon government decision to regularize the service of different mortgage department. on completion of 5 years of services.
Regularization, right? Yes, Lordship. In this case, Lordship, deduction was for 3 years. Subsequently, Lordship, one judgment was there, Sanjita Ray, Lordship. In Sanjita Ray, it was decided that the entire work source period and the master roll period has to be counted for the purpose of pension.
Ah.
That is after regularization.
After regularization.
This will come into effect after regularization.
Okay. And he is annexing some similar cases. You are annexing some similar cases. Supporting documents, annexer 5.
Lordship.
This is
Similar.
posthumous.
Yes, Lordship. Posthumous 1 year, Lordship. 1 day employment, Lordship, then pensions has been granted, Lordship. That is why we have annexed, Lordship. Okay, annexer 5, 6, page 45, 48. Page 45, Lordship, page 48.
How about it?
This is of 2005.
What proposition has been laid down in this Jagdit Singh
Jagmeet Singh, Lordship.
or Prem Singh?
Jaggo versus this, Lordship. DD Vasan.
How can a work charge employee
Lordship.
to be treated as a person appointed against sanction post?
Lordship.
The concept of work charge is completely different
Yes,
for a particular work.
yes, Lordship.
For a particular work in works department.
Lordship.
It is a particular project
Lordship.
against which
Lordship.
the work charge employees are employed.
Lordship.
So for that, how can it be a sanction post?
No, Lordship.
Because see the stand in the affidavit. Lordship, it can be assumed that he was appointed in a sanctioned post, Lordship, because for
How
20,
can it be-
no, probably the concept has to be looked into, sir. Lordship. What is the work charge? What do you mean by work charge employee? Lordship, basic concept of work charge is that he has been appointed for a particular kind of work, Lordship. That is the main concept, Lordship. Now here, Lordship, he was appointed against the person who had transferred from that post, namely of sectional assistant. Lordship.
That's also that just because he has been transferred,
Lordship.
that does not mean that he is holding a sanction post.
No, Lordship, that is a regular post, Lordship. That is evident from his grade pay. That increase in his grade pay as per the ROP, Lordship. And Lordship, for 20 years, that post has not been filled up, Lordship. If it was
If
subject,
there is a post,
Lordship.
then only, sir. What is mean by work charge? They continues.
Lordship.
They continues for indefinite period of time.
Lordship.
But the very concept of work charge employee is completely different. Yes, what is Joggo?
Jago, Lordship. This is regarding the appointment of temporary employees, Lordship. If work charge employees are also temporary employees, Lordship. But Lordship, he has rendered a continuous period of service, and that is what the Supreme Court, the Apex Court, has emphasized in this case, Lordship. Working for in a particular post for a
Now, every connotation has different meaning.
Lordship. Now, Lordship, if Lordship looks at paragraph 20, Lordship, page 9, Lordship.
Was there any earlier litigation by the husband of the petitioner?
No, Lordship.
Which paragraph you want to?
Lordship, paragraph 20, Lordship. 20, 21, and 22, Lordship. Then paragraph 26, Lordship.
20.
Lordship. It's on page 9, Lordship. Page 9 of the judgment. Can I read, Lordship? It is well established that the decision in Uma Devi Supra does not intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions of the state or its instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements.
However, the appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions and for a considerable period, the need for fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can, over the time, transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In the recent judgment of this court in Vinod Kumar and others versus Union of India, it was held that procedural formalities cannot be used to deny regularization of service to an employee whose appointment was temporary but has performed the same duties as performed by regular employee over a considerable capacity of regular employee. The relevant paras of this judgment has been reproduced below. Lordship, then paragraph 6 and 7. But Lordship, what it emphasizes is, even if a person was appointment was irregular or temporary, but Lordship, if a person renders continuous service for a long period of time without an unblemished service record, he is entitled to regularization, Lordship. In this case, Lordship, the petitioner's husband had served for 20 years, Lordship. In a 20 years, for 20 years, Lordship, and he was receiving great pay, Lordship. So it means, Lordship, if he had worked for 2028, which was his regular date of retirement, he would not have been regularized even till then. Does that mean that his work is not, appreciated or needed by the government, Lordship? His work was needed. That's why he was employed for 20 years, Lordship, for a period of 20 years. Lordship, I would like to read paragraph 22, Lordship, of this case, Lordship. The pervasive misuse of temporary employment contracts, as exemplified in this case, reflects a broader systematic issue that adversely affects workers' rights and job security. In the private sector, the rise of the gig economy has led to an increase in precarious employment arrangements, often characterized by lack of benefit, job security, and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding principles of fairness and justice bear an even greater responsibility to avoid such exploitative and employment practices. When public sector entities engage in misuse of temporary contracts, it not only mirrors the detrimental trends observed in the gig economy, but also sets a concerning precedent that can erode public trust in government operations, Lordship. It clearly shows, Lordship, that the apex court is against this kind of practices, Lordship. A person, after rendering 20 years, he has been termed as temporary and is denied pensional benefits when he has expired, Lordship, and his wife is there. What are the judgments relied by the respondents?
Lordship, first one is 2008 2SCC 310. But unfortunately, today I am not having the copies of those judgments. I'm only citing the citations. At least 5 judgments.
How many? Yes, next.
That is one. Second one is that Nagaland judgment, Lordship, 2022 SCC online, SC 818.
That is regarding
One-day regularization.
One-day regularization.
Yes.
That has been deprecated.
Yes.
And that was also posthumous.
Yes. It was regularized. Subsequently, Supreme Court said, no, it cannot be done, Lordship. That was the statute. Third one is WA 1 of 2022. That is a division bench judgment passed by our High Court.
Let us have that.
WA 1 of 2022.
What is the name of the?
This is Ujjwala Narjari versus State of Assam.
Just have it.
Next one is 2023 1 SCC 570. This is Sunita Burman versus Commissioner MP Housing Board. So this is a recent judgment, very recent judgment, Lordship. My Lord Justice Sanrasuru was there. Another judgment is there, Lordship. Same one-day regularization. Review petition 124 of 2012. My Lord Justice Ansari, Lordship. And so far as Jaggu is concerned, Lordship, that was placed in many other cases before our High Court also, Lordship. but it was even never paid any heed to that judgment, Lordship. It was decided against that. And if Lordship comes to the appointment order, Lordship, at page 20,
Because many judgments, this side, that side, that creates the
now, so
difficulty.
far as this particular issue is concerned, stand of our High Court as well as of the Supreme Court is quite clear. So far as Jaggu is concerned, that is a different context, Lordship, in the fact situation of that particular case. Even in this petition, Lordship, his prayer was for regularization. If Jaggu is to be, relied upon, Lordship, there is no question of regularizing, Lordship. It's a dim regularization kind of thing, Lordship. What is the requirement? If without regularization, he is claiming pension, it's a dim regularization kind of thing, then his prayer is for regularization only. He's saying regularize my service for 1 day and give me pension benefit. If Lordship comes to page 20,
Yes.
of the writ petition, that is his engagement letter, Lordship.
Yes.
His name is page 21 of that copy. Fifth line, Lordship. Page 21 of that. Next page.
Yes, fifth line.
Type copy, page 21, Lordship.
Yes.
In the interest of public service agents, Sri Bidang Basumatari, son of late so-and-so man, is hereby appointed as Workers SA in the post of Sri Amadur Rahman, Workers Section Assistant. So that person was also a Workers person. That was not a fixed, sanctioned post, Lordship. Somebody who was holding a Workers engagement, and in his place, the petitioner's husband was appointed. And in the affidavit, Lordship, it is quite clear that he was never appointed against any sanctioned vacant post.
Okay, this appeal number 1 of 2000.
Same, Lordship. Herein also the petitioner was claiming family pension in respect of our deceased husband, works as employee, Lordship. Notification. এখন সঠিক আগত 12 ঘন্টা দিব পিছফালে
Yes, Mr. Das.
Lordship.
This Ujjwala Narjari.
Lordship.
Let us have page 21.
Lordship.
Now, the appellant's husband was appointed as work charge sectional assistant.
Lordship.
Your order is 26/1998,
Lordship.
right? The appellant's husband was appointed as work charge sectional assistant
Lordship.
on 12/5/1997,
Lordship.
1 year ahead of you. Then filed office order dated 12/5/1997 was working in Kokrajhar PWD
Lordship.
division
Lordship.
in a scale of pay of rupees 1,065, ending with 2,095.
Lordship.
Thereafter, the services of the appellant's husband was extended, renewed from time to time. Come to the death certificate. Until he passed away on 6/5/2017. Just 6 days, less than 20 years. Right? While still in service. Pension and other retirement benefits have been claimed by the wife.
Okay.
A division means single judge perhaps allowed. Or
Dismissed.
let us see allowed or
Restriction
dismissed.
was dismissed.
Dismissed. Then division means upheld it. What are the change of circumstances? Absolutely nothing with this case. Ujjwala Narjari's
Lordship. That and
case. Absolutely same division, same pay scale, work charge, sectional assistant,
Lordship.
just less than 2 years. His case was better than your period. Right? Died in service while he was work charge sectional assistant.
Lordship.
Wife claimed pension and all. Single just declined it. Division bench declined it.
Lordship.
You can have a look. This is the fact, paragraph 4.
Lordship. I don't have.
Video. Video. WA Rate Appeal number 1 of 2022. And this is decided on 13/3/2023. Absolutely similar, nothing distinguishable. And posthumous regularization for 1 day is also, that is these 2 orders which you have annexed.
Lordship.
Perhaps in view of the judgment in Nishubi Asumi.
Nisibi Assam is there, our Upendas is there, Lordship.
Which one?
Upendas is also there.
Open?
Upendas, State of Assam versus Upendas. Lordship, initially this notification of 2012 was set aside by the single bench.
2012. Which
Yes,
notification?
there is a office memorandum of 16 June 2012. 2 decisions were there. One is no more regularization. And second one is no more regularization can be undertaken by creating supernumerary posts for 1 day in respect of those workers and MR workers who were engaged prior to 1993, 1/4/1993. Lots of this was challenged.
Which was challenged.
Initially, it was set aside by the learned single judge. Then appeal came, Lordship, State of Assam versus Upendas, and that judgment was reversed. So that decision remains. Thereafter, Lordship, this Nagaland judgment is subsequent to this Upendas, Lordship.
Okay.
Lordship, Upendas, I beg to submit, Lordship. Upendas is not for persons working in a sanctioned post, Lordship. That is for temporary employees who are not employed in a
But this
sanctioned.
case is absolutely similar. I have not found any distinction about it. And so far as these two orders similarly situated, now that has been explained in Nichevi Asumi,
Lordship. I mean, we granted a short accommodation, Lordship. A short it may be granted just to go through.
I'm giving you the order, you read it, any distinction.
Lordship.
His position was better.
Lordship.
Just 6 days less than 20 years,
Lordship.
but declined. So I am bound by that decision.
Lordship.
Same division, same pay scale, same post, same number of years, died, wife claimed, everything is similar, nothing distinguishable.
Lordship.
Problem lies there for the court. That judgment is binding. I cannot extricate myself out of that judgment.
Lordship.
Judicial propriety demands, consistency demands. Otherwise, these are the facts.
Lordship, these are the facts.
We have your satisfaction.
Lordship.
Go. If you see your judgment annexed,
Lordship.
or you come to the meaning of work charge, page 68. Page 68.
Lordship.
Or Nichevi Asumi to Nichevi Asumi. State of Nagaland and Nichevi Asumi. See that paragraph, Lordship. Work charge establishment is material and qualitatively different from a regular establishment. That is the position.
In our High Court, Lordship, full bench judgments of Jiten Kolita, therein also this concept has been elaborated.
This concept is clear. So it is other than regular establishment. And this is the proper explanation of work charge establishment. Delay, it will want to delay. Heard, Mr. As does. Counsel for the petitioner. Any accountant general? Okay. Mr. P. Nayak, learned. And Mr. P. Nayak, learned. Additional Advocate General Assam, along with Mr. Ardhor, Standing Counsel, Public Works Department, for the respondent number 126. And Mr. Mr. B Das, Learned Counsel, on behalf, representing Mr. B Sharma. Central Government Council or Standing Council, Accountant General for the respondent number 7. First of para. The petitioner herein is the widow of one late Bidang Bosumotari. First of the repetition under Article 226 of the Constitution of India is preferred by the petitioner as the widow of late Bidang Bosumotari seeking a direction to the respondent authorities to grant pension and other benefits for the services rendered by the petitioner's husband as a work charge employee under the Public Works Department within bracket building, Kokrajar Building Division, Kokrajar, till his death. Post of such a direction has been sought for seeking another direction for regularization of the services of the petitioner's husband, at least for 1 day prior to his death, by considering the service periods rendered by him as an work charge employee as a qualifying service. Post of para. The basis for seeking the above reliefs is an office order number 128 of 1998-1999, whereby and whereupon the petitioner's husband came to be appointed as an work charge sectional assistant or section assistant,
Generally, we call it section assistant.
Section assistant. Full stop. As per office order, comma. Late Bijang Bosumotri had been appointed as an work charge section assistant in a post of one Amdadur Rahman, comma, another work charge section assistant, comma, who had already been transferred from the Kokrajhar Building Division. Post of the office order was issued under the hand of the executive engineer, PWD Building, Kokrajhar Building Division. Full stop. The office order further mentioned that late Bidang Bosumantri would be paid a scale of pay of rupees 1065, page 21 also, up to 2095 per month, plus all other allowances as admissible under the rules with effect from the date of joining. And he was posted in the office of Gukhaigaon PWD Building Subdivision. Post of the case, the further case of the petition is that the petitioner's husband, while working as work charge section assistant under the Kokrajhar Building Division of the PWD, expired on 26/2/2018. After continuously working for a period of 19 years, 8 months, 4 days. Full stop. Where the Learned Counsel for the petitioner has submitted that since the petitioner's husband had rendered nearly 20 years of service, 20 years of uninterrupted and continuous service as a work charge employee in the Department of PWD, comma, the services of the petitioner's husband are to be regularized at least for 1 day prior to his death. And after grant pension and other benefits, counting the period of service he had rendered during his lifetime as the qualifying service for the purpose of calculating the pensionary benefits. Full stop. Where the Learned Counsel for the petition has referred to a number of decisions to buttress his submissions. Full stop. He has referred to the decisions in it will give you page 53 আছে Prem Singh versus Swainson. Then Jogu Jogu versus Union of India and others. Habib Khan, State of Uttarakhand, PS 74. Full stop. He is also referred to instances, two instances wherein the respondent PWD Public Works Department had where are those had
Page 45 and 48, Lordship.
regularized services of diseased employees who had died prior to regularization, comma, wherein supernumerary posts were created for the purpose of regularization of their services for 1 day in order to extend pensionary benefits to the family of those diseased employees. Full stop. Para. On the par contra, the Learned Council for paying for the official respondents have contended that from the office order dated 26/1998, comma, it is evident that the appointment of the petitioner's husband was purely temporary, and it was a condition that his services could be terminated at any time without assigning any reason thereof. Full stop. The in any view of the matter, comma, an work charge establishment is completely different from a regular establishment, and there cannot be any sanction post in an work charge establishment. A submission. It is submitted that the petitioner's husband was appointed against a sanctioned post, which was left vacant due to transfer of another work charge section assistant. And full stop, the fact that the petitioner's husband who was appointed against a sanctioned post can be is discernible from the fact that from time to time, the petitioner's husband was granted revised pay. As per the Pursuant to revision of pay.
One paragraph is there as regard payment of regular salary, Lordship. That's submission was made in another case, Lordship, but that is the argument, Lordship.
Because we are bound. We are bound by this decision. Absolutely no difference.
Lordship.
I cannot go out.
Lordship.
My hands are tied. The decisions in ready to give the citations. Open to decision.
First one is that Uttar Haryana Bijli Vitran.
Decisions in State of Nagaland, Nichevi Asumi, 2022, 18 SSC 371. State of Assam versus Upen Das
Imato dia copy to the
2020, within bracket 5, CLT 605. আৰু কি আছে?
Lordship, first one, Uttar Haryana Bijli Vitran Nigam Limited versus Surjit Devi. That is, this is 2008 to
Have been
SSC.
cited. Post op. It is submitted. It is further submitted that the case, the decision in Ujjwala Narjari versus State of Assam and others, read appeal number 01/2022 within brackets, is squarely on the point. Post op. The factual metrics obtaining in Ujjwala Narjari has been specifically referred to. Post op. Para. On perusal of the documents submitted in support of similar instances, it is noticed that the respondent Public Works Department had earlier regularized services of two employees, namely late Rajendra Ram, two work charge employees. Late Harishchandra Sharma and late Rajendra Ram. For one day preceding their dates of death by creating supernumerary post in order to extend pensionary benefits to their families. Post. In Nichevi Asumi Supra, the respondent was the wife of and workers employee who died in harness on 28/8/2005. Post of. The respondent's wife, without regularization of his service, the respondent wife approached and claimed for regularization of the services of her husband. And for grant of family pension. Poster. The Honorable Supreme Court has declined the prayer for posthumous regularization and consequently, the claim for pensionary benefit. Poster. Para. The at this stage cover the facts. Fact situation involving Ujjwala, Narjari, Supra, need a mention. Poster. The husband of the appellant was appointed as work charge section assistant on 12/5/1997 via an office order dated 12/5/1997, and he was working in Kochugaon R subdivision under Kokrajhar PWD within bracket R division in a scale of pay of rupees 1,065 to 2,095 per month. Poster. The services of the appellant's husband service period was extended and renewed from time to time. Poster. It was during his service as an work charge section assistant, the appellant's husband expired on 6/5/2017. Poster. The appellant approached the court seeking a direction to the respondent authorities to prepare and pay pension and other unpaid retirement benefits like gratuity, group insurance, pension, etc. Poster. By filing a writ petition. Poster. The writ petition, filing a writ petition WBC number 6193/2021. Poster. The writ petition was dismissed by an order dated by learned single judge by an order dated 24/11/2021, and the appellant carried the matter before the division bench by way of an intra-court appeal. Poster. The division bench, after considering a number of precedents, took notice of the fact that the appointment of the appellant's husband made by office order dated 12/5/1997 contained a stipulation that the appointment of the appellant's husband was purely temporary and could be terminated at any time without showing any reason thereof. Full stop. Finding no merit in the intercourt appeal, comma, the division bench rejected the case of the appellants. Full stop. As there are striking similarities in the case of Ujjwala Narjari and the present writ petitioner, and a decision of a division bench is binding on this court, comma, this court has no other option but to follow the binding decision of the division bench rendered in Ujjwala Narjari Supra. Full stop. Para. In view of the above, comma, the other contentions raised by the learned counsel for the parties are not required to be, are not necessary to be deliberated upon. Full stop. Para. Consequently, para. Consequently, comma, this writ petition being devoid of merit, comma, is liable to be dismissed. So it is accordingly ordered. The route is appeal thereafter SLP.
To mention item number 34.
30?
34.
Yes.
Which I believe that will be a less possibility the matter could reach. So if your lordship may just fix this matter for some other day.
Mark it, you look score as well. When do you want? Maybe after 15 September.
15 September.
After 15 September. It is of which year? 2024.
Your lordship may just
Okay.
fix a date. Fix a date.
Okay. Deliver on the prayer of Miss Swati B. Borua, within bracket TG. Okay. Who is the other side?
Other side is the Miss B. Sharma, CGC. No, he is my junior.
Okay, list the case. On data ready.
Deeply obliged.
Item number 16.
Lordship, my senior Mr. Nayak is on legs in a different court after some.
Is it? Yes, sir. What is the issue here?
denied pension due to date of birth.
Date of birth.
Wrongly reflected in that
Okay,
service.
after some time, let him be free.
Item 17.
Kindly pass over for timing, Lordship.
That's a compassionate appointment, Lordship, immediacy and Devrata Tiwari is concerned.
I have not yet gone through Devrata Tiwari.
Next week, Lordship.
Let us see. Pass over for timing.
Yes, Lordship.
Timing.
Item 18.
Lordship, kindly have a look on the last order, 21st August. Certain observation made by this court. Thank you. এইটোতো আগৰ পিছৰ নহয়, ছেপ্টেম্বৰ কৰিছিলো নাজানো মোক জনা আচ্ছা Oh, yes. Remaining itu like 5,54,000 remaining. That's a different one, 2, 4, 5. 2, 1 di dili. Itu yata analysis. Itu dito pamana ni. Itu report kami pada sini. Magini ko report different dependent on hard cases. Koi kiya report ahi dilo konta ho jaba.
Yes, what is the matter about?
Lordship, matter is relating to payment of arrears salary and other benefits. And we have been directed by this honorable court in previous orders that initially 2 lakhs deposited was 2 lakh rupees was deposited, and remaining 5,54,000 should be deposited within 3 months of 15th of July. So on previous order, we have been engaged recently in this matter. We got the instruction as per this municipality Nalbari Municipality Board letter dated 27/8/2025, which I have just placed before this honorable court. Decision has been made that the remaining arrear salary of out of 5,54,000, 1 lakh has been deposited day before yesterday. It is not placed in record, but I have got the instruction that the submission may be made, and remaining 4,54,000 will be paid in 3 installments as per this letter dated 27/8/2025. As per the direction of this honorable.
3 installment means what period?
Period before 15th of October 2025.
The last of the installment is 15th October.
Yes. The last
15th
installment, 15th October.
So it means about 45 days from today.
Rightly, Your Honor. It is in terms with order dated.
Leaving aside all these other contentions,
Milord.
entire amount he is saying
Yes.
by 15th of October, meaning that thereby about 25 days from today,
Yes.
the entire amount will be paid to you. Otherwise, without going into the file,
Yes.
it appears to be reasonable.
Yes, my lord.
Period. It is not a long period that they are seeking.
Yes, my lord.
45 days.
My lord. And this point, my lord, if your lordship take the order 23rd, 6/25, certain observation, that observation, my lord, 23rd.
Leaving aside, I am saying that I have not read the file.
The proposal they have in this, I found also reasonable. My lord.
That appears to be very reasonable.
Yes, my lord, 23rd June 25, my lord, order, my lord. Lordship will find certain observation made in the last paragraph, my lord.
20?
Sorry, my lord, date 23/6/2025. When the personal appearance made by this authorities concerned, certain observation made by this court, my lord.
So as on that, you have received 3 lakhs.
But so far as the yesterday,
We'll
paid 1 lakh,
take it, we'll
no
take it
communication.
as a statement from the
Council.
council, right?
Yes. Yes.
The board has directed.
And moreover, my lord, since my lord, additional affidavit,
To release.
it is stated that it is to be noted that a pensionary dues receivable by the petitioner in that order, my lord, quantified by the authorities Nalbari Municipal Board has been disputed by the learned council. By this submission recorded, my lord, in our additional affidavit,
So
lord, people have-
firstly, according to their version,
7 lakhs total.
54,000, 7,54,000, 18 rupees.
As per office.
Pensionary benefits.
Yes,
That is
my lord.
their
Yes, my lord.
same is pending for
Yes.
payment.
Yes, my lord.
Out of that, you have received 3 lakhs.
Three.
So 4,54,000 might be remaining.
Yes, my lord. Yes, my lord.
Now, you are also disputing the
I'm
quantification
not
of the amount.
disputing, my lord. Their own record, their own office record in additional affidavit, my lord, issued by head assistant Nalbari municipal, but my total amount 9 lakhs for the 18, but they are saying the 7 lakhs. This is the only question involved here, my lord, and I'm not. It is their
Right.
record.
What is your calculation? What is their calculation according to the Nalbari Municipal Board?
That this is the
petitioner is to be released a sum of
Petition.
rupees 7,54,000.
Yes,
And where is your statement? That 9 lakh something?
my lord.
Where from you are saying?
My lord, page 20, annexure A, additional my affidavit.
Additional affidavit.
Yes, page 20. But when they appeared before the court, they are saying the 7 lakh something, but we don't know this fact, my lord.
Okay, let us have a calculation sheet.
Yes,
proper.
yes, my lord.
Then
Yes.
everything
Matter-
will be clear how they have arrived at 7,54,000.
Yes, my lord.
And this whether this calculation is correct or wrong.
Yes,
How
absolutely.
they have arrived.
Yes, my lord.
Lordship,
Detailed calculation sheet you provide.
the
on the
additional
next day?
affidavit may be served upon me because
Huh?
since I have been newly engaged, the additional copy is
Okay,
not.
okay, he will provide.
Yes, my lord. Okay.
So you provide the breakup, right?
Yes, sir.
Please allow him to have a look.
Lordship, I have given.
Last page.
Last page, page 20. It will.
You are Mr.
Mr. H. Talukdar.
Tarundar. On the next date, you provide a breakup of 7,54,000 and the justification of this particular sheet.
Yes, my lord.
Which one is correct?
An affidavit may be allowed to be filed.
Make an effort and provide detail breakup. How we have arrived at the figure of rupees 7,54,000. We keep it after 1 month. We'll see how many installments you have deposited in a
Yes.
time.
Yes, my lord.
So that before arrival of 15th October, we can see the progress,
Right.
right? Because you are saying that 3 installments.
Yes,
So
as per compliance of
within
the-
1 month might be 1 or 2 will be due.
rightly.
We'll see that.
We'll see.
Okay. Heard Mr. P.K. Deka, learned counsel for the petitioner. And Mr. H. Talukdar, learned counsel for the respondent number 5.
5.
He is municipal board. Full stop. When the case was listed on 23/06/2025, a statement was made by the chairperson and the executive officer of the respondent Nalbari Municipal Board that the petitioner is to be released a sum of rupees 7,54,018 rupees as his pensionary benefit, and the same amount was pending for payment till date. Full stop. On 23/6/2025, a direction was made to release a sum of rupees 2 lakh to the petitioner on or before 15/7/2025. Full stop. It is submitted by Mr. Talukdar, learned counsel appearing for the respondent, number 5, that pursuant to the order dated 23/6/2025, comma, a sum of rupees 2 lakh was released immediately and recently, comma, another sum of rupees 1 lakh has been disbursed to the petitioner, leaving a sum of rupees 4,54,018 as outstanding as on date. Full stop. He has further submitted that the remaining amount the board is contemplating to disburse the remaining amount in 3 installments, with the last of the installments on 15/10/2025. Full stop. Para. Mr. Decca, learned counsel for the petitioner, has referred to a statement annexed as Annexure A to the additional affidavit to submit that, as per the calculation provided in that statement, the net amount payable to the petitioner towards leave encashment and area salary, etc. The total gratuity, leave encashment benefit, and area salary was 9,04,018 rupees. And there is this discrepancy in the calculation of the amounts. Head assistant will লিখে দিব, calculation sheet provided by the head assistant of Nalbari Municipal Board. Full stop. In view of the statement made by Mr. Talukdar, counsel for the respondent number 5, comma, this court finds it proper to list the case after a month so as to see the progress made by the respondent municipal board in depositing the remaining amount in installments. Full stop. Mr. Talukdar, the respondent number 5 shall also file an affidavit explaining the discrepancies noticed as regards the outstanding amounts payable to the petitioner, that is, 7,54,018 and 9,04,018. There is some similarity. 18 rupees is same.
Yes, same. 18 same.
Additional affidavit additional affidavit by way of an additional affidavit giving the breakups properly.
Yes, Lord.
Lordship, this letter may be brought on record today.
Yes.
What record?
That the letter dated 27/8/2025 by Municipal
one?
Board.
27 is what?
Your Honor, this payment area salary, that schedule breakup, Your Honor.
Which one schedule breakup?
Your
Here.
Not, that is the, that is,
We are not interested in auditors account now.
this one. এখনো থাকিব, অৰ্ডাৰত দিব দিছে, অডিটৰ ৰিপৰ্টো দিব দিছে।
You comply. We put it on, oh, not possible, Mr. Deka, to list after 1 month,
Yes,
Right.
yes, yes, yes.
because
Yes,
vacations are
independent of this
intervening.
progress will,
Ah.
yes.
So, Uncle,
Immediately after
as per the
vacation.
statement, as per the statement made by Mr. Talukdar, a sum of rupees 1 lakh will be paid on or before 15 September 2015. And another sum of rupees 1 lakh will be paid on or before 30/09/2015. Oh, sorry, 25. Full stop. The remaining amount, sum of rupees 2,54,018, will be paid on or before 15 October 2025. Full stop. So last one, 1 month, 1 month line to cut it. Lays the case on 17/10.
Yes, absolutely. Oblige me.
You take this. Since you have made the statement before the court, that is enough.
My lord, it may be kept on record. I have the copy.
Yes, my lord.
It may be kept on.
Yes.
Okay, M. Bhattacharya, additional senior government advocate for the respondent number 1, 2, 3. প্রথমতে লিখে দিব 1, 2, 3. 1. Okay. Who is respondent number 5? Any amendment or side?
Chairperson.
Okay. You are respondent of
Yes, yes.
5.
5.
4, executive officer.
It was represented by the
You, 1 to 4. 1 to 4. You kept this audit account, do not like to have many documents, extraneous, outside documents. I keep it this letter regarding 15/9/39, 15/10.
Yes, my lord. Like,
Items 19 and 20.
This would have passed over a timing.
Timing.
Yes, ma'am.
Second half timing is very difficult. First half timing is, yes, okay.
Lordship, additionally, the PNAC is also in Lakes, my lord. He is also leading me in this matter, my lord.
What is the case about?
Regulation of service for the petitioner.
Okay, some other reason.
Yes.
Your senior is not available. Okay. Mr.
Kekolita.
Line Constable petition has sought listing of the case on another date. M. D. Boda, counsel for the respondent number 3. And who is there? Miss H. Burua, counsel on behalf of Mr. P. Nayak, additional in Assam, are in attendance. Okay. List the cases on a date in the week commencing from video.
15. 15/9.
Oblige.
Item 21.
Yes.
My lord, the more moot issue in this matter is the petitioners who were appointed as agriculture development officers under Rule 3F. Your Worship, there is a procedure laid down under Rule 3F for consultation with the APSC. Now, our contention is that that procedure is mandatory. Without leaving that procedure incomplete, Your Lordship, you cannot proceed to then fill up those posts in another by a regular selection process in the pretext that the appointments to the petitioners are temporary. When the powers under 3F are appointed, are used, Your Lordship, particularly the second part of Rule 3F, which squarely covers permanent posts, then by not consulting the APSC, shirking your duty, you cannot later take the ground that the appointments are temporary and then seek to fill up the appointment process.
Assam limitation, Assam Public Service Commission limitation of functions, I think. Yeah, tell us any.
Because Rule 3F,
Thank
Your
you.
Lordship, it is directly in tune with the provisions of Article 320, Your Lordship. There a mandate is given on both the state and the central government to consult the public commission, the state or the central public, union public commission in all matters of employment. There is a list.
Is there any process of selection earlier? In your case?
In our case, as per the agricultural service rules, the substantive appointments have to be made at the pleasure of the governor by the APS.
3F.
3F of the Assam Public Service Limitation of Functions Regulations 1951. Lordship will have the substantive regulation 3 first, Your Lordship. Regulation 3 provides that it shall not be necessary for the commission to be consulted in matters relating to methods of recruitment to civil services and post or the suitability of the candidates for such appointments in the following cases. Then we are concerned with F. When an appointment is to be made by direct recruitment to a temporary post created in the service, if it is necessary in public interest that the appointment should be made immediately and reference to the commission would cause undue delay. There is a semicolon here. So that is one instant. Provided that if the post has been sanctioned for or is likely to last for more than four months, the commission shall, as soon as possible, be consulted in all matters mentioned in subclause 3 of Article 320 of the Constitution.
Provided that.
Provided that if the post has been sanctioned for or is likely to last for more than 4 months, then the commission shall, as soon as possible, be consulted in all matters mentioned in subclause 3 of Article
What is
320.
subclause 3?
Yes.
Constitution. Proviso is an exception.
Proviso
can work out in many ways.
In my understanding, Your Lordship, this should not be an
320.
exception.
You said subclause 3.
3. The Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted. We are here concerned with A, Your Lordship, on all matters relating to methods of recruitment to civil services and for civil posts.
Yes.
In the particular case in hand. Otherwise, the duty is to consult in all the 5 classes of conditions of service which are
All
laid down.
matters. Why B is not relevant?
B, for the first portion of B, Your Lordship, regarding qualifications are relevant. Here it won't perhaps be an
The
issue
principles to be followed.
because otherwise the posts were advertised and we fulfilled the eligibility criteria as per the rules. The concern is regarding the process which was followed.
Yes.
So now our stand is that,
Now, what is your case?
yes, our case is that pursuant to a selection process initiated by pursuant to a cabinet decision of the government of Assam, a recruitment process was undertaken by the government of Assam under the aegis of the Assam Agricultural University. An advertisement was issued, Your Lordship, for
Where is
filling
that
up-
advertisement?
Yes. The advertisement, Your Lordship, will find at page number 43. The terms are at 44. The
The poster, what?
Agricultural Development Officer.
These are by set of rules.
These are by a set of
Otherwise-
rules. The Assam Agricultural Service Rules of 1980.
officer. Where is the detail? This is the detailed advertisement.
Yes, the details your lordship will find at page number 44. We are concerned, your lordship, if your lordship has page number 46,
Okay.
46 clause 11, it should be K, your lordship, it's mentioned as L here. The bottom of the page. The final appointment on 3F regulation after selection is subject to satisfactory police verification report and final medical examination as per existing norms. In case of police verification report or final medical examination found unsatisfactory, the candidature of such candidates will be rejected outright. This is important. The appointment will be initially for 4 months and may be extended 4 months as per norms pertaining to 3F regulations of APSC regulations. Now,
So if we read that,
yes,
then it is to be consulted.
consulted.
And
Now,
then when it is going beyond 4 months.
it is to be, if the post is completely, appointment is completely temporary, then the requirement of consultation is completely waived, your lordship. But if the appointment is against the sanctioned post or the requirement for appointment is more than 4 months, then the commission has to be consulted. In this case, your lordship, the records reveal that the appointment was against sanctioned post and it has definitely continued for more than 4 months. So if I may first take your lordship to the cabinet memorandum at page number 42, where the decision was first taken to fill up this post, your lordship. Lordship will see these are the extracts of the minutes of the councils of the Council of Ministers, page 42, your lordship. Approved, the Council of Ministers approves the proposal of Agriculture Minister to include posts of Agricultural Development Officers left vacant after recent selection by APSC for recruitment under Regulation 3F. So there was first a regular selection process. The posts which are left vacant in that regular selection process are to be filled under Regulation 3F. That is the decision taken.
Also approved proposal of the minister. Post of left vacant.
Yes. Then, your lordship, the advertisement which I had just taken your lordship to, that advertisement was issued.
Did you appear in the selection process?
Yes, yes. We have been appointed, all of us are appointed, your lordship.
No, did you appear in the earlier selection process, regular?
If we appear in the earlier selection process. No, before that. I do not have
The
exact-
advertisement was of which year?
Advertisement was 1/2/2021.
And this decision, cabinet decision? 17/2.
12/2/20, yes, 17/2/2020. Signed on
2020.
Yes, the meeting was held on 12/2/2020.
Yes. The advertisement was subsequent.
Subsequent. Then, your lordship, a second advertisement was issued on 8/10/2021. It's a continuation of the first advertisement. It again says that the appointment will be through the 3F mode. And it says that people who have already applied in the first advertisement need not apply. That your lordship will find at page number 47.
Yes.
This is the date of this advertisement is 8/10/2021.
Yes.
Then somewhere in the first week of January, your lordship, 2022, a select list for selected candidates for successful select list for candidates who are eligible to sit in the written examination was published, your lordship, at page number 48. So all of the petitioners were there. Now, prior to conducting the examination, your lordship,
This petition is by how many?
109.
Okay.
How many petitioners? 109 petitions. 109 petitions.
Okay.
119 petitions.
This is a select list.
Yeah, this is not, this is the list
For written,
for written test.
who has cross-written or?
No, who are eligible to sit in the written.
Oh, select list for.
Now, if your lordship comes to the communication at page number 71,
1 minute. So this is after screening of the application.
yes, after screening of the application. The
Yes.
judgments. The communication on page number 71 is a letter written on 15/6/2022 by the Secretary of the Agriculture Department
Hmm.
to the Registrar Assam Agricultural University. Your lordship will see, I'll just read out, your lordship. In inviting a reference to the letter on the subject cited above, I am directed to inform you that the Government of Assam Agriculture Department has examined the matter and accordingly following information is submitted for taking onward necessary action. We are concerned with number 2 here. The candidate for appearing in the interview against each sanctioned post will be invited in the 1:4 ratio for all categories. So the selection process that has been undertaken or that is ongoing will be against sanctioned post. And candidates will be invited in a 1:4 category, a 1:4 ratio across all categories. Then again, your lordship, in the minutes of the core committee, your lordship will find it at page number 72, constituted for conducting the examinations. The government lordship will see that in the discussion, there is we are concerned with resolution number 1, where the Agriculture University has decided that the Government of Assam, the Department of Agriculture will be requested to submit an up-to-date reservation roster for the aforementioned post as requested by letter dated 13/5/2022, which is being proposed as worked out by the core committee as follows. So it will include reservation. It is again sanctioned posts.
Yes.
Yes. Finally, your lordship, it was decided that it will, again sanctioned post, it will be called in the ratio of 1:6. So against that was decided on 25/2022. That the number of candidates will be called in the ratio of 1:6. Then the results of the written examination, your lordship, were declared.
So it included written examination and
And
interview.
interview both.
Yes, where is that?
The results, your lordship, will find at page number 74. Is the date of the report? Check.
Declared when?
It was declared, your lordship. Your lordship, the date is not discernible from that. It is, but this is otherwise a list which has been made available to us. Then, your lordship, a notification was issued on 27/9/2023. 27/9/2023. Laying down the date for interview 5 hours, your lordship. This is, your lordship, will find at page number 76.
So interview must precede declaration of results.
Definitely, prior to that.
So 10/4/2023 onwards.
Yes.
Were the dates of interview.
Yes, your lordship.
So declaration must be after appeal.
Must be preceding that, your lordship. The date is not discernible from the top.
Yes. Then
your lordship will have the document at page number 77.
yes. This is of date 6/5.
Yes, this is dated 6/5. I'll just read it out. This is relevant.
Hmm.
With approval of the Government of Assam, by memo number so and so dated 6 May 2023, the selected candidates as per recommendation of the selected committee for the post of Agricultural Development Officer Assistant Agricultural Officer and Junior Engineer under the Department of Agriculture, Government of Assam, against advertisement number 3 and 6 of 2021, dated 1/2/2021 and 8/10/2021 are notified in Annexure 1, 2, and 3. The appointing authority shall have the liberty to re-verify the original documents before giving the offer of appointment. The selected candidates are requested to collect the provisional appointment letters from the Directorate of Agriculture on 13th of May 2023. There is nothing in this order otherwise which says that the appointments will be temporary. Because the process of selection adopted and the minutes of the cabinet meeting, they say that it is against sanction posts. Now, the names of all the petitioners who are before your lordship, they figure in the selected list, your lordship. The order of appointment, your lordship, which was finally issued, that your lordship will find at page number 199. 199, your lordship.
119. What is this order? Page 82?
Page 82, your lordship, is for this is an order for your lordship. What is 82? Yes, sir. Some of the petitioners, your lordship, were in this order. The others are in the second order. Your lordship.
This is appointment order.
Yes, your lordship. I'll read from 82 or 82 itself, your lordship.
Yes. There it is clear, 3F.
Yes. As per recommendation of the selection committee of the Assam Agriculture University, the following candidates are hereby appointed as Agriculture Development Officer under Agriculture Department, provisionally under Regulation 3F of the APSC so-and-so, Regulations 1951, the scale of pay of rupees so-and-so, 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 plus other allowances, as admissible with effect from the date of joining in the places of posting, as indicated against each for a period of 4 months from the date of issue of this letter. The appointment is subject to satisfactory verification of documents, character and antecedents. Further extension of the services tenure will be at the discretion of the Agriculture Department. The appointment is purely temporary and may be terminated at any time without notice and without assigning any reasons thereof. His or her service is liable to be transferred to anywhere in Assam, including the hill areas, autonomous council areas. The appointees joining state government service on or after so-and-so shall not be governed by the existing Assam Service Pension Rules 1969 and orders issued thereunder from time to time. Their pension and other retirement benefits will be governed by the new pension scheme 2005. She should join in his or her new place of posting on 1st June 2023. Now, your lordship will kindly see this 4 months, your lordship, they get this from Rule 3F. They have acted on the presumption that the appointments are temporary in nature, but their later conduct will reveal
Yes.
In fact, the document which I was referring to, your lordship, the same order, it's at 2 different places. Their later conduct, your lordship, will reveal that this appointment, though they are seeking to give it the color of a temporary appointment, it is in fact a permanent appointment against a sanctioned post, and it goes against their own notification regarding the temporary appointments under 3F, which says that such appointments there cannot be more extensions, there cannot be extensions more than twice. Now, the stand taken by the respondents in the affidavit to counter
Your services have been extended by different notifications.
different notifications.
Subsequently.
There have been more than 4, there have been till date more than 4, your lordship.
Then your prayer for regularization.
In effect, your lordship, if your lordship has the prayer, what we are saying is our appointments already have the are already clothed with a degree of permanence. Now there is
Why
a-
you have annexed all those signatures here?
Your Lordship, all of them have put their signatures.
Oh,
Yes.
page 160 onwards?
Yes, Your Lordship.
What is the reason? Give petition of the status of regular employee. Not to bring the post.
Yes, this is the
Another person.
representation, so that is why everybody has signed.
Okay.
Now, Your Lordship, the primary contention is that once an appointment is made under the second part of Rule 3F,
Under
the
what's the
second part of Rule 3F,
second part of Rule 3F?
yes, Regulation 3F, against the sanction post and the appointment, because Your Lordship, first part deals only with post appointments of an urgent nature, so that the time which may be required or may be spent in consultation with the APSC, that can be waived off in certain circumstances.
Sanction post. Then under regulation, what you said?
Regulation 3F says that the second part of Regulation 3F says that when the appointments
What second part proviso?
provides, because Your Lordship, though the word provided appears, it in fact envisages two separate classes of appointments, Your Lordship. Because the proviso precedes. preceded
So second part of 3F says what?
that if the appointments are against sanction post are expected to continue for more than 4 months, then there is a duty cast on the government of Assam, on the state government, to consult the APSC as fast as possible, as soon as possible.
So not consulted?
Not
What is the consequence?
Now the
That will
consequence
flow
is-
out of it?
because they have not discharged their duty, Your Lordship. In the stand taken in the affidavit is that
So petition has to be regularized.
the stand taken in the affidavit is that our appointments are temporary. So now they are seeking to fill up those posts by a regular selection process.
They are seeking to fill up those vacancies by regular appointment.
Regular appointment.
So here this and writ petition.
In the writ petition, we are not challenging the advertisement process only because, Your Lordship, there are sufficient posts in the department to accommodate both the petitioners, and even if the entire selection process is allowed to continue.
Let us see the rules.
Yes. I've got the. What to do? The rules are there. Yes. These are the rules.
This is agriculture.
Assam Agricultural
No,
Service
no.
Rules 1980.
Post.
The post is Agriculture Development Officer.
Agriculture development.
Lordship,
In the schedule, where is the post?
in the Lordship will find it that Regulation Rule 3, I have been informed that the post of Agricultural Extension Officer that has been redesignated now as Agriculture Development Officer.
Post of
Agricultural Extension Officer.
Agriculture Extension Officer.
Yes. Your Lordship will find that in Rule 3.
Rule 3.
Rule 3. Your Lordship.
1 minute. Rule 3. No, it is now
Yes. that is my-
Agriculture Development Officer.
Yes, I've been instructed. It's a class 2 post.
Yes.
The process of direct recruitment, Your Lordship will find in Rule 6.
Rule 6.
Yes, sir. This is the process which is to be ordinarily followed. Here they have bypassed that process.
Direct. 6.
Rule 6, direct recruitment. Subject to sub-rule 3 of Rule 11, direct recruitment to the cadre of so-and-so subject matter specialist and agricultural extension officer and junior subject matter specialist in so-and-so shall be made by the governor on the basis of the recommendations made by the commission in accordance with the procedure hereinafter provided. Before the end of each year, the government shall make up an assessment regarding the likely number of vacancies to be filled up by direct recruitment during the next year and shall intimate the same to the commission together with the details about reservation for candidates belonging to scheduled caste, scheduled tribes or any other category as laid down by the government as provided under Rule 17 and carry forward of such reservation. The government shall simultaneously request the commission to recommend a list of candidates for direct recruitment in order of preference. The commission shall make a selection in accordance with the scheme of selection prescribed by the government in consultation with the commission. The commission may hold such test or interview and undertake scrutiny of publication and other documents as may be considered necessary. The commission.
Okay.
So now here they have supposedly invoked the power under 3F, which is available to them. Now, if I may take your lordship to a judgment of the Honorable Apex Court, though it was in the nature of how 3F is to be interpreted, where the commission is to be consulted for initiating discipline.
It is on 3F.
It is under 320 has to be interpreted. 320, your lordship. 320. It is not on 3F. How 320 is to be interpreted when a commission has to be consulted for initiating disciplinary proceedings against the officer. The presence of the word
3F
shall,
has been interpreted by many judgments, I think.
lordship, this aspect perhaps has not been discussed here, lordship. That if the-
320.
320, yes, your lordship.
Okay, so let us see.
If I may read from
Say online.
because my whole endeavor, your lordship, is to establish that there is a
Yes.
My whole endeavor, your lordship, is to establish that under the provisions of Article 320, read with the proviso or second part of 3F, your lordship, there is a duty cast upon the government of Assam or the state government to consult the commission. Now, when the appointments are against sanctioned posts and then or they continue for more than 4 months, then they cannot be treated in the same manner as temporary appointments under the first part of 3F. So, if I may read, your lordship, from paragraph number 6 onwards.
6.
Yes. This otherwise the judgment, your lordship, only concerns with disciplinary matters, but the scope of Article 320 has been discussed. Article 323C is in these terms, and 320 because C is concerned with disciplinary matters, that has been quoted. I'll just read the first part of 323. The Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted. The word shall is there. And A and B are on all matters related to methods of recruitment to civil service and for civil posts. And the first part of B says, on the principles to be followed in making appointments to civil services and posts. Now, how 320 is to be interpreted is discussed in the succeeding paragraphs. Article 320 does not come under Chapter 1, headed Services of Part 14. It occurs in Chapter 2 of the part headed Public Service Commissions. Article 320 and 323 lay down the several duties of a Public Service Commission. Article 321 envisages such additional functions as may be provided for by the Parliament or a state legislature. Article 320 and 323 begin with the words, "It shall be the duty," and then proceed to prescribe the various duties and functions of the Union or State Public Service Commission, such as to conduct examinations for appointments, to assist in framing and operating schemes of joint recruitment, and of being consulted in all matters related to methods of recruitment or principles in making appointments to civil services, and on all disciplinary matters affecting a civil servant. Perhaps because of the use of the word "shall" in several parts of Article 320, the High Court was led to assume that the provisions of Article 323(c) were mandatory, but in our opinion, there are several cogent reasons for holding to the contrary. In the first place, the proviso to Article 320 itself contemplates that the President or the Governor, as the case may be, may make regulations specifying the manner, this is important, Your Lordship, may make regulations specifying the manner in which either generally or in any particular class or case or in particular circumstances, it shall not be necessary for a public service commission to be consulted. The words quoted above give a clear indication of the intention of the constitution makers that they did envisage certain cases or classes of cases in which the commission need not be consulted. If the provisions of Article 320 were of a mandatory character, the Constitution would not have left it to the discretion of the heads of the executive government to undo those provisions by making regulations to the contrary. If it had been intended by the makers of the Constitution that consultation with the Commission should be mandatory, the proviso would not have been there, or at any rate in the terms in which it stands. That does not, this is important, Your Lordship, may kindly take note, that does not amount to saying that it is open to the executive government completely to ignore the existence of the Commission or to pick and choose cases in which it may be consulted. Once relevant regulations have been made, they are meant to be followed in letter and spirit, and it goes without saying that consultation with the Commission on all disciplinary matters affecting a public servant has been specifically provided for in order first to give an assurance to the services that a wholly independent body, not directly concerned with the making of orders adversely affecting public servants, has considered the action proposed to be taken against a particular public servant with an open mind, and secondly, to afford the government unbiased advice and opinion on matters vitally affecting the morale of public services. It is therefore incumbent upon the executive government, when it proposes to take any disciplinary action against a public servant, to consult the Commission as to whether the action proposed to be taken was justified and was not in excess of the requirements of the situation. If I may take a pause here, Your Lordship.
Yes.
Now, this judgment goes on to discuss the requirement of consultation when disciplinary proceedings are initiated. Now, the other four classes from class A to E, Your Lordship, the same principles of interpretation will apply. There is a duty cast on the executive government to consult. Now, that duty, Your Lordship, it will be subject to any rules that the appropriate government may frame. In this case, they have framed a rule. The rule is the Assam Public Service Limitation of Functions Regulations 1951. In fact, Rule 3 itself says, Your Lordship, it starts with the lines, "It shall not be necessary for the Commission to be consulted in matters relating to methods of recruitment to civil services and posts, or the suitability of the candidates for such appointments in the following cases." So this is a rule directly made under that proviso. Now, what I am saying is the records reveal that the appointment is against sanctioned posts, and there have been 4 extensions and they are still continuing. So it is definitely, it has exceeded the period of 4 months. So without in their affidavit, they have not stated anywhere that there has been a consultation with the APSC, and the APSC has given its independent finding that the services of the petitioners are not required. What in fact they have stated.
Section 3 itself, regulation 3 itself is there in a substantive part that it is methods of recruitment to civil services or civil posts.
Yes.
Right. It
Yes,
is
Your Lord.
clear.
Yes.
So it is implied that sanction post.
Sanction posts.
Civil services and civil posts, these are sanction posts.
Because the first part.
No need to emphasize on the sanction post. It is substantive part is already there.
Why?
Sections.
Because.
Regulation 3.
Yes, the
Yes.
first part,
The proviso which you said, which you are submitting as second part to 3F, you say that if it is more than 4 months, right? It goes beyond 4 months.
but why I am trying to.
And plus it is sanctioned, the post has been sanctioned.
Yes,
Then commission is to be consulted as soon as possible.
because if your lordship.
In all matters, mention is subclause 3 of our.
Yes.
So this is the interpretation you have, this is the interpretation that has been given by the Supreme Court.
Supreme Court. Now the
So
first
instead of C, it is to be read as A.
A in this case.
That is your
In
case.
this. So my contention, why I was trying to create a distinction between sanction post and non-sanction is, the first part of 3F says that when the appointment is to a purely temporary post created in service, then the consultation is completely done away with. If your lordship has the language of the first portion of 3F, it says, when an appointment is to be made by direct recruitment to a temporary post within a service, if it is necessary in the public interest that the appointment should be made immediately and reference to the commission would cause undue delay. Now, this has to be read with 3. If these two conditions are met, that the post is temporary and consultation will cause delay, then the commission need not be consulted at all. The requirement of consultation itself is completely done away.
So as against temporary,
Yes.
you want to say that the term is sanctioned.
Yes, if it was a purely temporary appointment, then the requirement of consultation is done away with, and then the government cannot definitely cloth it with the nature and the characteristics of a permanent post.
No, this is not temporary service. It is temporary post
Temporary post created in
Post.
service.
created in the service.
Yes, your lordship.
Right.
So if for example, if you envision a situation where there are a category of permanent posts.
That is why I have asked the
Yes.
query that sanction post is also in the service.
Also in the service.
So it is permanent post part.
Or that is what I am trying to submit, your lordship. That it will be in the second.
And the service rules itself is there, temporary
Yes.
post and in the schedule.
Yes, your lordship. So now, if I may take your lordship to what has happened thereafter. In the affidavit, they have brought on record an office memorandum of the personnel department. Which your lordship will find at page number 261. They are perhaps relying on this office memorandum to say that once the appointment is under 3F, then there is no scope of making those appointments permanent.
Page
260.
Yes.
This is a notification of 16th of March 2015, the Personnel Department of Personnel. The subject is appointments under Regulation 3F of the APSC Limitation of Functions Regulation 71 and the measure for regularization of certain such appointees. Now, if your lordship has the narration, various departments of the government of Assam from time to time exercising powers under Regulation 3F of the APSC Limitation of Functions Regulations, henceforth referred to as Regulation 3F, gave appointment to various candidates to tackle emergency situations faced by those departments. It talks about emergency situations, the first part. Many such candidates initially appointed for 4 months under Regulation 3F are continuing in the services year after year in an ad hoc manner without regularization. All these candidates have already crossed the upper age limit specified for appearing in the interview tests held by APSC for the posts that they are holding, and therefore left with no chances to get regularized in the post. Evidently, this situation has arisen mainly due to unwarranted exercise of the powers under Regulation 3F by the departments, failure on the part of the APSC to hold interviews in timely manner, and also the failure of the on the part of the departments to move APSC for regular appointments. So they envision this part also. As communicated by the concerned departments, all these regulations 3F appointees now under consideration are working in regular vacancies, mainly under various orders of the High Court, and drawing their regular salaries as admissible. However, those cases where the incumbent concerned have not appeared to APSC test interview, and those whose cases are sub judice are outside the purview of this OM. Now, government, after careful consideration of the matter, after taking into account of the views of the Finance and Judicial Department in individual cases, the views offered by the Advocate General Assam on the matter, and also the observation of the Supreme Court in so-and-so 1990 SEC 2228, have decided to lay down the following policy guidelines in the matter of appointment under Regulation 3F and regularization of the existing 3F appointees, as aforementioned, so as to prevent emergence of any similar situation in future that may compel government to resort to such measure as this. Now, if your lordship has the third guideline, any fresh appointments made under Regulation 3F after issue of this OM shall get only 2 extensions of the term, and then their services shall stand automatically terminated. Personnel B department shall communicate the date of termination while allowing the extension of the second term. Then number 5, personnel B department shall not allow.
Yes.
Personnel B department shall not allow any further extension of the term of any employee appointed under Regulation 3F which exceeds beyond 6 months from the date of issue of this OM, and will take up the matter with each of the departments and APSC for advertisement of such posts within the stipulated time. There shall be no person appointed under Regulation 3F with effect from the first day of December 2015. So, this OM, your lordship, was meant to address the problems which arise by application of the principal part of 3F. And they themselves admit that there in such temporary appointments, there cannot be more than 2 extensions.
So how many you have got?
Here we have got, after the appointment, 4 extensions. All of them are on record. And now, your lordship, if your lordship has the advertisement at page number 295. They are seeking to, your lordship, fill up the post. Now, initially, your lordship, there was a perception on the perhaps on the part of the respondents also during these proceedings that these posts did not include the posts of the petitioners. But now that has been clarified in the affidavit that it actually does. Now, as per my instructions, there are 499 posts in the cadre of Assistant Agriculture Development Officer in the department.
This advertisement is 195 posts.
195 posts. And there are 119 petitioners. Now, even if this advertisement, because we have not challenged the advertisement, your lordship. So even if this process continues, there are sufficient posts available in that cadre for the government to exercise its duty under Article 320, consult the APSC, and then if, depending upon the report of the APSC, consider the case of the petitioners for making their appointments permanent.
What is your prayer?
Prayer, your lordship.
My lord, I'm sorry. There is only one thing. Possibly my lord doesn't know. It's raining very heavily since last more than half an hour.
Oh, I
So
I don't know.
we are all worried. We are
Okay, I don't know. I don't know. I am not aware of raining.
Since last 40 minutes, it's raining heavily.
Okay.
Prayer, your lordship, will find it page number 39.
Is there any request? Indirectly?
I'm being told by lawyers outside that none of us will be able to go.
But leader of the bar would say.
That's it. Because you know, we are also waiting for our case.
Here he is raining heavily, Lord.
Yes, yes.
Prayer.
Page number 39. I beg your pardon, Lordship, there are 5 extensions. Not 4, 5 extensions.
5.
Five.
First is basically regularization.
We have worded it as that we should be given the status of our.
Status.
Because if it is in the second
Not
category.
to bring the posts held by under the purview of future recruitment process. Now they have brought,
Now they have brought.
if there is a statement
Yes, there is.
that these posts
Are-
which are held by the petitioners are under the purview of the advertisement,
Yes.
then
Then
second prayer is,
Second prayer, perhaps your Lordship, because otherwise we have not challenged the.
you have not
advertisement also.
challenged the advertisement.
Yes, we have not done it in these proceedings.
By separate petition also not,
Not yet.
not by IA also.
In the IA, your Lordship, if your Lordship has the IA that we have filed,
Yes.
if your Lordship has the prayers made in the IA, it is, we have filed the IA, but we have only said that till this issue is decided, the status quo at least should be maintained in regarding this selection process. There is an additional affidavit also in the IA. At page number 23 of the IA, 23-20. Well, I am a very new entrant in this proceedings, your Lordship, because
You have done such a hard work in filing a bulky IA.
Petitioner wishes. Numbers of petitioners.
page number 23, we are saying that at least till this issue.
Status quo.
Status quo.
Status quo.
Because otherwise the IA we cannot expand the main.
Your
prayer also.
status quo may remain till completion of the selection process, perhaps. We don't know. We are not,
That I is-
we are not delving into that.
So
Ah.
my specific instruction otherwise is, this is perhaps would be of some relevance. 449 total posts.
Where from you are seeing?
This is the instructions available with the petitioners.
Where?
This is not on record. This has been formed to me. That,
My,
perhaps if I'm
perhaps
wrong, they'll-
Mr. Soikia would know.
yes, otherwise.
My senior used to say, if something is mathat ase khatat nai, it is of no value. It is not on record.
It is not on record, but
Okay.
449 posts, there are sufficient posts available to consider the case like this. Even after, if this advertisement is not interfered with, and it is allowed to continue, there are sufficient vacant posts available.
Yes.
That is I reserve my right to a rejoinder, your Lordship.
In fact, this issue is Lordship was pleased to already settle in the engineering services case. Same issue. Very long hearing took place. I think that
what is
is
the case?
reported in 2022 6 SCC page 308. Saurabh Kumar Parasar versus
so-
identical case. They are the assistant engineers.
Okay.
Same case. I
Any
think
appeal?
Squarely covers this.
Any appeal?
If it appeal also, I think it was dismissed. I am citing this case in lot of other cases. Appeal nahi kora na. And the recruitment process, everything is over.
Same thing, 3F.
Yes, let him go through this judgment and whether he can distinguish the present facts.
There also all these, I think.
Same
pension-
identically,
pension-
the assistant engineers in various one department, and we started the fresh recruitment, regular recruitment process.
Yes, yes.
Then,
Mr. DK Mishra was there perhaps.
yes. Diganto Das was there.
Yes.
And
Also-
DK Mishra was there on and off. Yes, his name is there. Yes, Lord.
Yes, perhaps.
I'll just have a look. I was not aware of this. I'll have a look.
So, Lordship may be pleased to adjourn this matter. Let him go through it
On all
because he will have to
fours.
distinguish this.
Appears to be on all fours.
Yes, sir.
But he developed a very good argument.
Yes,
Lordship,
yes, yes.
Because his father was developing a different argument. He argued the case. Now today he's taking over a new
Right.
line, and I am little bit
Yes, yes,
on
I
a
am.
defensive way.
Yes, he has
We have-
taken us to a different part. So I have not noticed that part. Second part of,
Today his collar will be all up in
Tarmi
the
has
corridor.
provided for,
Really grateful.
Good. So if he goes through it, Lordship,
Ah.
then in that case, my learned senior friend, Pawan Tiwari's prayer will also be met.
when Mr. Pathak,
As per your lordship's convenience.
if you distinguish, we'll put it in the next week. If you distinguish subject to business of the court, if you want to distinguish, then
Lordship will put it in the next week because otherwise I am informed that this election process will culminate on 30th of September, you know.
okay.
And their extension is also, I think, up to
Till
30th
30th.
September.
We can put it on 9th of September if
Nine, too many cases of
Tuesday.
Lordship. Could it be little bit earlier, Lordship?
second and fourth, many cases already listed.
In that case, 11th.
Yes, good enough. 11th. Okay. We have to keep for further hearing.
Further hearing.
Okay. Mr. K.P. Pathak, Learned Counsel for the petitioners, has advanced his submission. As his submissions is not complete. Let the case be listed again on 11 September 2025 for further hearing. Mr. D. Hoikia, Learned Advocate General, Assam, assisted by Mr. B. Chaudhary, Standing Counsel, Agriculture Department. Mr. Mondo, okay, Mr. T.J. Mondo, and Senior Counsel and Standing Counsel APSC, assisted by Ms. For the respondents are present. 11/9/2025.
Highly obliged.
বহুত বৰষুণ নেকি? এই মোৰ সৌৰভটো ওলাই দিলো।
I think the 16.
Mr. Tiwari, you have raised apprehension.
My esteemed senior commissioner, Mr. Ashish Gupta for the petitioner. I am for the respondent.
Yes,
So that is it. Ultimately.
I can allay your apprehension.
True, my lord, but if he doesn't concede, I can't help it. Otherwise, we'll have
Yes,
to wait.
Mr. Raining cats and dogs as per,
It's raining.
But
it will be
the
likely
problem
to
is
be
that
inundated.
the next week he will be not in Guwahati.
That's true.
That is.
Next week is also not possible for this court. Already we have
The problem with me when
big series of matters.
when I am facing Mr. Pawan Tiwari.
Oh, yes.
He has a very, very problem.
Yes, yes. Formidable.
So,
We can fix it that subject to convenience. When both of you are available.
He is a very busy lawyer.
Yes, yes.
It is up to him. Any date, whatever he picks. I
Yes.
tell you.
No, no, give it
Item
to us
number?
16th of September.
Item number?
25.
Okay, 16th we can do.
16th of September.
Item number?
25.
25. Okay. Mr. A. Dasgupta, and Senior Counsel for the petitioner, and Mr. P.K. Tiwari, and Senior Counsel for the respondent are present. First up, and has sought for and agreed to by the Senior Counsel for the parties, list the case on 7, you say 16, 16/9/2025. Yes, Mr. Padgiri.
Item 16. मतलब तीन आयोग मतलब कुछ ना पेटी आती है
Hmm?
तीन आयोग से
You have apprehension regarding flood?
no
16. You stay in higher where flood is not 16 item 2. এইটোৱে নেকি? আপুনি কোনটো দিছিল? 25 টো খুজিছিল। সেইটোৱে মই খুজিছিলো। মই সেইকাৰণে এইটো বুলি ফিৰাই দিলো।
This one is the master role worker
Master role
he joined on service मतलब 4
till the joining. There is regular as Khalasi.
That's Khalasi मतलब it effect from 22/7/2005
Date of birth.
Regulation order मतलब
On date basis.
21
Entered his date of birth.
Thereafter, after regulation, service book has been prepared, and their date of birth, recorded as per school certificate submitted by the petitioner. School certificate can be seen, page 28.
Who is respondent number 6?
Respondent is executive engineer, Yes, I'm with it. Thereafter, kindly see, service book, page 32, Their date of
Let us see your document. Where is your regulation?
regulation, page.
Appointment, initial appointment.
When initial appointment 1984, kindly say page 23, type copy. And original.
23 is what? This is part of this order.
Order, and original.
Creation of post for regularizing the services of work charge master workers engaged prior to 1493 and are in continuous service without interruption, still working. On the sanction of so-and-so of work charge and grade 4 post as detailed and so-and-so in connection with regularization of so-and-so and were engaged prior to and still working. The report will not be filled up by any other post other than the so-and-so from the officer of the engineer is requested to issue order of appointment for the purpose of regularization public after
Date of engagement,
positively without fail.
1983.
He is. He also issued an information receiving the notice immediately. Yeah, here,
Page
date
20.
of birth,
Date of birth as per regulation order, 19/7/1948.
19/7/1948.
Page 26.
What is this, page 23?
23 is not type copy, Type copy of page 26.
Page 26.
Serial number 22, Sukram Ragha. Date of engagement is reflected, 4/6/1984.
You are Sukram Rava. 1 minute. Because you should. Your date of birth is shown as 19/7/1948.
48. And thereafter, I am asked to submit the school certificate, Accordingly, I have submitted school certificate, page 28,
Wherefrom we can see that left the school.
is 28 my lord school certificate. And date of birth recorded as 1/1/1956.
So you want to rely on this?
My lord. And on the basis of that state certificate, my lord, the respondent authority, my lord, prepared the service book, my lord, page 26, page 32. My date of
When did
birth,
you enter service?
1984, my lord,
1984,
4/6/1984.
4/6/1984. Oh, এখন এই সিটু করে। এইটো হেৰি হ'ল। Enter service on?
My lord, 4/6/1984. Thereafter regularized as Khalasi, my lord, with effect from 22/7/2009.
Your service book.
Service book, my lord, page 32, my lord. Entry of date of birth, my lord, original.
What is written there? Executive engineer.
1956.
Then?
As per full certificate.
Then what he said in?
On the basis of the said, my lord, entry, my lord, I start the department.
No, what he has written, executive engineer, page 32.
32, my lord.
What he has written?
Written, my lord, supplemented, my lord, underlined the 1/156 and rectified, my lord, 19/7/1948. Without knowledge of the petitioner.
Firstly, what is noticeable, right? Your order, this is 3rd October.
3rd October regulation order, my lord.
3rd regulation order, 3rd October 2005.
5.
That is regulation order.
So to that, my lord, I have not.
And your birth certificate was dated 2006.
Full certificate.
Right, 2006.
2006.
It was issued in 2006. And in the regulation order, your date is date of birth 19/7/48.
48.
You are a patient man.
Hello.
You seem to be a very patient man. Because for 22 years you have been reading in class 7. Very patient man. Is it not?
And that is his school certificate.
Yes. He is a very patient man. Had it been a matriculation year, Seva, might have failed you.
He was studying in class 7.
Yes, class 7. That is what.
And at this.
Come to page 28.
Yes, my lord.
Come to page 28.
Yes, my lord. Yes,
Come to page 28.
28.
Read content. Left the Borigaon High School on 1/2/1978.
78.
His date of birth at that date, according to admission register, 1/1/1956. Reading in class 7.
As per admission register.
Admission register. Why should we believe it? Because there is a sanction order and 33 October 2005. There it is there. And come to page 22.
List number.
Executive engineer was directed. to enter the details after properly examining the biodata of the personnel on or before 6/10/2005 positively without fail. So on that date, his document was available is only this one that you have shown me at page 26.
26.
So he had a justification to enter the date as 1948 because he was instructed somebody, and this may, I don't know where is the original service book. Do you have the
As my lord, but now I am hanging, my lord. No pension has been granted, my lord.
right? Do you have the service book original, sir, Mr. Nayak? When it was opened actually?
Lordship, so far as this case is concerned, two issues are there. One, date of birth, and second, to entitlement to pension.
That is a different one.
That is so. So far as the first case is concerned,
The date of birth.
date of birth. If Lordship comes to the regularization order, page 26,
Yes, I
it
have
is
seen.
clearly mentioned there 19/7/48
Right.
and
definitely.
date of retirement 31/7/2008. And
Okay.
on the basis of this date, Lordship, his service book was prepared. And in the service book, it is written as 19/7/1948, page 32.
There must be some.
It originally, some correction is
Which
there.
one is original? That is the only question is that.
Now, if Lordship comes to the prayer,
The original one.
now if Lordship comes to the prayer, what is his actual prayer?
What?
My understanding, Lordship, the petition, I mean, my friend is not, I mean, submitting what has been pleaded in the petition, Lordship. Lordship comes to the
Do
prayer.
you have the service book?
My lord, next, my lord.
No, original.
No, my lord. It is the department.
Because now,
not
initially I did not, I thought that,
It is not.
now after having a look, I have a clear doubt that 1948 was the original entry.
Yes. And that is what,
And this 1/1/1956 was a subsequent entry.
Yes.
I initially
and
thought,
that is what,
initially I thought 1/1/1956 was the original entry.
48 was the original,
Ah,
subsequently
okay.
corrected as 56. Now, Lordship is come to the prayer, Lordship. Very prayer, Lordship. First prayer. Edict of nature shall not be issued to set aside or quash the subsequent entry of date of birth 19/7/48. According to him, 19/7/48
So original
is
was is
subsequent.
the issue. The ink will clear the issue.
No, that is the one aspect, Lordship. If Lordship comes to the affidavit, Lordship, filed by the petitioner. Page 20, Lordship.
Page
20. So this is a document on oath, Lordship. Page 20. Lordship, may kindly see what is his age, 75 years. If in the year 2023, his age is 75 years, then his date of birth is 1948, not 56.
If we say 2023.
I have calculated
2023, 75,
1948, his date of birth.
11. So 1948.
So that is correct, Lordship. It is admitted.
1948, then also I'm getting pension, my lord.
Please-
Show me, I'll stop the payment, whatever you,
My lord.
original one.
Original service book in the department, my lord.
No, I think after retirement, it is given to the petitioner.
Department pension proposal has been, my lord, forwarded.
That
to
I
the
have
AG,
to
my
enter,
lord.
Lordship. He has already been granted the terminal gratuity, I think. So
But, another 11 lakhs, kindly see page
that is the overpay, overstay.
48.
Overstay.
48.
So that is why I'm saying two issues. One is overstay and second one is pension.
Page 48, my lord, kindly see, my lord.
Please, when did you, sorry, initially, your retirement age was 31/7/2008.
8.
Then what happened subsequently?
My lord, I am.
You retired.
Start up to, my lord, in the year 2015, my lord.
Oh, on the basis of the subsequent entry,
My lord.
which you say that original entry.
My lord.
And that is why that correction, Lordship.
Service book, my lord, I have annex, my lord, kindly see, my lord.
A service is verified up to so and so as per rule.
Yes, 31, my lord.
Page 31.
31.
Let us see original one. 31.
31 5 copy, my lord.
Now, from the handwriting, it looks like the 1948 was the original entry.
Service verified up to 36 2015.
Page?
Page 31, my lord, 5 copy.
Mm.
Annual increment.
No, I have seen the original one. Page 44.
Page 44.
I always look at originals. However illegible it may be.
Annual increment granted as per office order dated on the 23/7.
So thereafter, what happened? Pension.
Pension, my lord.
Page 48, Lordship.
Page 48.
Sanction the terminal gratuity of 1,13,823.
Could not make out how the overpayment of rupees.
11,06,540. Page 48, my lord.
So about 7 years of service
My-
is to be adjusted from the admissible termination.
And terminal gratuity sanction as because, my lord, as per my lord, qualifying service, my lord, after deduction of 6 years, my lord, he has, my lord.
If you don't know, but perhaps Sukram Ravai is suppressing some facts.
Yes, Lordship. And the recent judgment, Lordship, our division bench, if it was to his knowledge, and in spite of having knowledge, he suppressed, then we are entitled to recover, Lordship. That one order, and so far as pension is concerned, maybe he is entitled.
No, that is, you are not here for recovery. Will not, his prayer is, one is that subsequent.
No, both, Lordship. First, he wants a correction of the date of birth. Second, pension. Pension, maybe he is entitled, Lordship. That deduction we may not probably would like to do.
Maybe overpayment, he
That
has,
Sanjita Ray's husband is.
he has also worked. But how much service? His service is regularized. 2005.
Yes. It was-
2005, and you say that service will be ending on 2008.
He should have retired in 2008.
But he continued up to
in
2015.
Then also, my lord, 24 years completed, my lord.
No.
If, my lord, 2008.
No, pension is okay, Lordship. Pension, Lordship, that Lordship may allow, Lordship. Sanjita Ray by following pension.
Terminal gratuity, my lord.
That is the second issue, Lordship.
Second issue, my lord.
But to come to a finding that this was not the original entry which you have projected, where from we? Have you filed any?
Lordship, I will try.
You have filed an affidavit.
Affidavit I have filed, Lordship, but no details is there, Lordship.
No, then how can I arrive?
No, Lordship may pass a
Seeing at the photocopy.
service book, Lordship.
Because this arrival of finding will be very improper.
Lordship.
On the basis of an photocopy.
In my understanding, Lordship, that this affidavit is sufficient. But if Lordship directs, then I'm ready to place.
No, otherwise something will be vulnerable again, litigation.
It's a document on.
It should be foolproof, so that it should be given a full stop here.
Lordship.
Otherwise,
no issue.
State resources, judicial time.
Yes, Lord.
It will not stop here.
Lordship.
Matter will be carried. The time
I understand.
of the judicial division bench will be spent
service record.
deliberating on it.
Lordship.
If it's the quickest possible time you can get, I'll.
Lordship will grant me 2 weeks.
I see the color of the ink.
Lordship.
That will cleanse the issue. Mr. Pargiri will also make submission then on the color of the ink.
And at the same time, Lordship will not forget the affidavit, Lordship.
Sure.
Color of affidavit, Lordship definitely.
75 years.
Admitted.
Admitted, and it is second entry. 1956 is second entry. That will be clear at least from the ink. Which one is original? Which one is older? Better sense should prevail on Sukram Rava. Mr. Nayak, when can, at the earliest, lest I forget.
2 weeks, Lordship.
2 weeks.
Lordship, I'll try to put it.
This will not keep further. If it comes before me, I'll be sitting here. So. it comes
Lordship will
before me.
keep this as part hard. Lordship had already
I
hard.
have
Lordship.
I have kept many part hard. Too long list of part hard is very difficult. We put it on a fixed date.
Lordship.
Here, particularly petitioner. Mr. Nayak, you are representing?
I'm representing for 7, 5, 6, and 7, Lordship.
Okay, Mr. P. Nayak, and it's.
BTC is the administrative department.
5, 6, and 7. Irrigation, Anupadhyay. Oh, 1 and 3, standing council. Mr. Chakraborty? Okay, standing council, accountant general 4. Pension, Ms. Bhattacharya, M. Bhattacharya, additional senior government advocate for 4. As there are overridings, with regard to the date of birth of the petitioner and 2 dates of birth are reflected. 2 dates of birth, 1947, 1948, and 1956 are reflected in the service book of the petitioner, comma, in order to resolve the controversy, comma, a look at the original service book appears necessary. As sought for by Mr. Nayak, additional advocate general, to produce the original service book, list the case on. Suggested it.
11.
It can be done. You can do it. 11. I go to the 16. That was a part. We'll go to. See, yes, 11 did it. 11.
Item 17.
That relates to this compassionate appointment, Malik.
Compassionate appointment.
Immediacy and Devrut Tiwari.
That is not.
That is
applicable now.
covered
This
here.
this has.
I have not yet gone through Devoto Tiwari.
That.
I have not read. I have said also.
Then otherwise, Lordship may fix the matter on 2nd of September, so that every decision will be produced. Whatever Devabrata Tiwari is saying,
Okay.
that has gone.
Gone.
But otherwise, some judgment has come, whereby it has been said that this whatever the compensation appointment is there, on merit it was decided, not on delay or otherwise. Even in full bench, even in division bench, on merit money. Only they are saying delay. Here in my case, there is no delay at all. Since in my case, DLC has recommended, then SLC also considered my case.
Okay, let me have the look at Devoto Tiwari, whatever support. And any other judgment? B. Chetri. For the
I think,
petitioner, J.K.
not-
Goswami, and additional senior government advocate for the state respondents. Okay. Sought for and agreed to by the Learning Council for the parties, list the case on so and so date 2/9. You said 2/9 for admission hearing. Lots. Okay, Devoto Tiwari Asan would like to know. I'll go through it. I don't know.
There, in the Devabrata Tiwari, there was no scheme, no policy.
Okay.
That is why it was decided now.
Our policy is.
And
Here we have the policy, and we have the Achut Ranjan Das case, we have the Ajit Pator case, we have the Fazirun Nasa case, and guidelines is there, already set up guidelines are there. And accordingly, case has been considered by this honorable court on the basis of the guidelines. And the policy also has been adopted by the government of Assam regarding consideration of compensation.
most difficult subject I find during my tenure, the other side, as well as the judge. Compassionate appointment. The most difficult subject for me.
And otherwise, lordship also have, I don't know, my lord, otherwise, these cases,
Okay.
this is a mercy cases, my lord. Otherwise, we do not have any, but mercy cases. Since all this.
As soon as a matter for compassion appointment comes, I find difficulty. Lord, sir. Really.
Yes. My lord, yes, my lord, these are. My lord, yes, my lord, these petitions comes from the destitute family, my lord. That is the, probably, that is why it is hammering to your lordships, my lord. Yes.
Lordship.
My lord, I have also found that when the 50 years was there, my lord, Supreme Court says that. Yes, ma'am. Not so. In our case, that is.
Anyway, next.
That medicine has been given by Supreme Court, only compensation in terms of the money.
For hearing,
Obliged lordship.
items 27 and 28.
Yes, sir. I'll do tomorrow one. Any,
Please, sir, lordship, 10 days time may be granted, lordship.
huh?
We have not filed our affidavit yet in the,
You have missed the file.
no, we have not filed our affidavit yet, so
Is it so?
yes, lordship.
Okay.
I'll pray for 10 days time, lordship.
I think have a look order dated 19/3 lordship. In in item number 28.
19-3. 2000?
25 lordship.
Okay. In the other petition you have filed.
No, lordship, in the similar matters, we have filed, not here, so we want only 10 days time, lordship.
Being a transfer subject, lordship, their affidavit is required. We have filed affidavit. That is what the record, recorded.
The council is respond number
Respond number 3 and 6. lordship.
3 and 6.
Lordship.
Who has filed affidavit?
Respondent one has filed it.
One has filed affidavit. And what is this other petition? Duta আছে নেকি?
Similar-
27 lordship.
28.
This is
Similar petition.
1129. 2804. Oh, here also it is not there.
Lordship. 10
You
days
file a
time-
consolidated one if the subject is
10
same for both the petition.
One
One will
sir.
cover. One affidavit.
Lordship, considering my suitability, they have sent a file to the chief engineer, lordship, Karbi Anglong. Now they are going.
If it is transfer subject, what is the prayer relief you are seeking?
Lordship, here, lordship, regularization and pension.
I think if it is, what is the department?
Irrigation.
Transfer subject, mister. That is your stand in the affidavit.
Not exactly lordship, but it's a transfer subject now.
Then, Ms. Camprai, when?
Lordship, 10 days,
10 days
Lordship.
will suffice.
Otherwise.
If you say it is, it will suffice, then okay.
2 weeks, lordship.
Item number 27 and 20.
28.
Once they have sent a file, lordship, they are taking a contracted stand.
Hmm?
They have already sent a file for consideration to the finance department.
Okay, let them there, otherwise,
In fact, lordship, the affidavit form.
Mr. GRM Mubarak,
Muttaki.
Muttak. Learning Council for the petitioners. Mr. N. Upaidhal, and Standing Council, Irrigation Department.
I am 1 and 5.
For the respond number 1 and 5. Same respondents, both the petitions.
Lordship.
Okay, Ms.
27, I'm for 3 and 6. In
Twitter দিব লাগিল তাৰমানে।
Item 27.
Respondent number 1 in both the petitions. S. Camprai, Learned Standing Council. Karbi Anglong Autonomous Council. For the respondent number, say,
3 and 6 in item 27.
item 27 and
28, I'm for 4 and 7.
4 and 7. And Mr. R. Boro, Learned Counsel, representing Mr. C. Borua, Learned Standing Counsel, Accountant General. For the respondents are present. Miss S. Kemprai, Learned Standing Counsel, KASC, for the respondent number so-and-so in 20 and respondent number so-and-so in 21. 20 or 21? Huh? 20 or 21? Has submitted that the respondent KASC authorities be granted 2 weeks' time to file a consolidated affidavit for the 2 writ petitions. The praise allowed the respondent authority in the case is ensure that the affidavit is filed within 2 weeks' time, as the writ petitions are of the year 2022. I think it will be impliedly last month. These are the cases on Swens.
I'm trying for a fixed debt box.
I have said, I don't relegate this court to the level of, I have said so and so, that means he will fix the date.
16/9.
If I go on making dates from calendars, 1 hour will be gone. 100 or 200 counsel
That's correct, Lordship.
pray for dates. Then I'll whole day I'll fix the dates. Will not pass any judicial order.
Because they are already.
I have said he will fix the date.
16/9. 16 September.
Please bear with that much only.
There are several observations that no further adjournment shall be granted. Order reflects, Lordship.
Obliged, Lordship.
Yes, anybody has some urgency.
The next item, let's make it fixed.
The Diriba and Sharma petitioner and the counsel for respondents are present. As for list the case on date to Diriba 29. Talukdar, you have some?
Lordship, I'm appearing for the respondent.
Yes, A.K. Talukdar, petitioner, and who is your respondent?
My lord, in 30 minutes.
30. Who is your respondent? Mr. H.R. Ahmed. HR. HR. For the private respondent. Okay. M, what is ID? Additional senior government advocate, huh? 30. DDO data, DDO.
Item
Yes,
number 33, Lordship.
31, Lordship.
33, Lordship.
1 minute.
Item number.
K. Kolita, yes.
Lordship, dismissal from service, Lordship. I'm paying for a date, Lordship, but only difficulty is that now earlier government appeared for the PCI department also. Now P. Sharma is appearing and S. Sukia. Lordship, may kindly direct the registry. No, PCI department also party, but on the last occasion it was submitted. Now PCI department.
Pisari.
Yes.
Standing counsel Pisari is to be reflected.
Yes.
Okay, K. Kolita. For a petitioner and Ms. M. Orazil and additional senior government advocate for the state response. Item 31, huh?
31.
Are present as for list the case on date to DDO. The name of the Learned Standing Counsel PCI department is to be reflected in the respondent side in the cause list. Yes, Mr. Mojumdar.
Lordship, item number 33, record is available. Record has come, Lordship.
Record has come.
And
FJ Mojumdar.
petition
Standing
is-
Counsel AAU available.
They are absent. I am paying for a date. Petitioner is bedridden. Lordship.
And is present. Learned Standing Counsel AAU is found absent today on call. Release the case on so and so. 33. Anybody from 34?
No,
Thirty
item
minutes
30,
on
praying for short date, my lord. I'm not.
Which
taking
one?
Pension, my lord. Item 30.
Which one? Item
30, 30.
30. You were respondent.
Yes.
Why you were?
We are not receiving pension, my lord. Due
Huh?
to the pendency of that case, my lord. Not receiving pension.
Aside your 30 অলপ আগত পৰিব otherwise rates are low
35 months. Last like about 12
AFNU মূল্য
short date my.
Okay. এটা দি দিব That's all. Huh? Item 2930. For you are for Accountant General, Miss Arketal. Okay, Mr. Arketal, লিখি দিব Huh? Standing Council Accountant General, huh? Present লিখি দিব ঠিক আছে